We'll call the meeting to order. Pre-K subcommittee. Yes, pre-K subcommittee. We will start with Delegate Askew.
Good afternoon, Mr. Chair, members of the committee. Mr. Chair, I have a substitute for my first bill.
When members are ready, I entertain a motion to move the substitute. There's a motion. Is there a second? Motion and a second to move the substitute. All in favor express by saying aye. Those opposed? Delegate Askew.
Thank you, Mr. Chair. Today I have House Bill 797. As some of you may know, there was a recent discovery of elevated levels of lead found in 27 Virginia Beach public schools. The levels were above the 15 parts per billion, or what the industry refers to as acceptable levels. When a child consumes lead, the mental, physical, and intellectual effects that has on them is frightening. A state law that was passed in 2017 requiring public schools to test drinking water, prioritized schools built on or before 1986 to be tested. 797, it requires each local school board to submit its plan to test and remediate certain potable water sources and report the results of any such tests to the Department of Health. The bill also requires local school boards to take all necessary steps to notify parents if testing results indicate lead contamination that exceeds the maximum contaminant level goals set by the U.S. Environmental Protection Agency.
Members, any questions? No. Delegate Cole.
Yeah, as you alluded to, I recall we passed legislation dealing with this issue a couple of years ago, I thought, anyways. I seem to recall it. Does the current law not require notification?
It does not, sir.
Or remediation?
Mr. Chair, to delegate, it does not.
Thank you.
Any additional questions? Anyone here speaking in support? Anyone here to speak in opposition?
Move to report.
There's a motion to report and a second. All those in favor express. Thank you so much. It reports on the 6-0 vote. Thank you.
Thank you, Mr. Chair.
Your next.
Yes. Mr. Chair, my other bill is House Bill 1344, which is the written reprimand authority for the Virginia Board of Education. I'm pleased to present to you 1344. I was given to this bill, as I stated previously, by the Virginia Board of Education. The board's authority currently is to issue written reprimands and limited to 2 code sections. Matters related to violations of secure mandatory tests and breaches of contract due to resignation. This language was added during the 2019 General Assembly session last year via House Bill 2325. While the intent of this current bill was to expand the board's authority more broadly, the Office of the Attorney General interpreted this change as being restrictive to the specific circumstances of violations related to secure mandatory tests and breach of contract due to resignation. Under the current law, the board only has the authority to suspend or revoke a license due to misconduct, except in those 2 circumstances I mentioned. Additionally, there may be circumstances in which the board takes no action against a license holder who has engaged in misconduct because the conduct does not rise to the level of suspension or revocation. Expanding the board's authority to allow for written reprimand does not require them to issue one, but does give them that option.
Any individuals here to speak in support?
Good afternoon, Emily Webb with the Department of Education. We'd like to thank Delegate Askew for carrying this governor's bill for us. As he mentioned, this bill really just provides another tool to the board when it's dealing with teacher licensure cases regarding misconduct. It does not require the board to issue a written reprimand, but does expand their authority when there may be cases that don't rise to the level of suspension or revocation.
Mr. Chairman, members of the committee, Kathy Birch with the Virginia Education Association. We actually asked Delegate Bob Thomas to carry this bill for us last session for a constituent of his who faced a license suspension or revocation for a more minor offense. And interestingly, the moral equivalent of this subcommittee last year, it was Delegate Lefwich who said, this section of code, I'm not sure if this language in this bill is going to get to the intention of the bill, which is to give the Board of Education one other option when teachers come before them. He thought it might be linked, just one particular action. And I actually saw Delegate Lefwich earlier today, and I said, the Attorney General agrees with you. So it was the intention of our bill and the bill filed by Delegate Thomas to allow for the reprimand to be available to the board for all cases. And this is truly a technical cleanup bill, and we're hoping that you support the bill.
Anyone here to speak in opposition? There's a motion. Is there a second? There's a motion and a second to report. Members will record their votes in just one moment. The time is now. 2 for 2, run.
Thank you, Mr. Chair,
6-0.
members of the subcommittee. Have a good evening.
Delegate Ward.
Thank you, Mr. Chair, members of the committee. I have for you House Bill 392. And first of all, I think we have two amendments that we're going to have to act on first.
Thank you, Mr. Chairman and Delegate Ward. It's a series of two sets of line amendments. So the first would be to remove volunteers from the bill. So that would involve striking language on 14 and 15, 16, and so forth, to remove all the references to volunteers in this bill. And then the second would be to update the list of barrier crimes to a more appropriate list. So that would be on, for instance, on line 16, where the references to subsection C of section 17.1-805, that would instead be as set forth in the definition of barrier crime in subsection A of section 19.2, 392.02.
Yeah, this was not the right.
Is there a motion?
Move the amendments.
Is it second?
Second.
There's a motion and a second. All in favor express by saying aye.
Aye.
Those opposed? Delegate Ward.
Thank you. This bill would permit each school board to employ or accept any individual who has been convicted of a felony or crime of moral turpitude that is not set forth in subsection 77.1-801. The Code of Virginia does not involve the sexual molestation, physical or sexual abuse of rape of a child, provided that the case of felony conviction, such individuals has had their civil rights restored by the governor, and the bill parallels provisions for contractors and their employees who have direct contact with students. I can tell you the reason why we're bringing this bill, and it comes from Hampton City School. They are having a difficult time filling certain positions because of some of the things that are currently in the code. And let me give you an example. You know, when Delegate Martha Mugler won her election to the General Assembly, it left a vacancy on Hampton City School Board. And as they were looking at the requirements or the certificate of candidacy qualifications, there were some things that just sort of stuck out. And it is, have you ever been convicted of a felony or other crime that would preclude you from holding office? And if you answered yes, the date of restoring your voting rights. Now, what this means is that while a convicted felon could run for office and be elected to serve on the school board, that same individual could not be eligible for employment with the school board. And this bill will certainly, this amendment will certainly just allow a school division to consider those individuals who have been convicted of a felony and had their rights restored for employment. Given the shortages of our teachers, bus drivers, mechanics, this flexibility would create a broader pool of candidates for the division. And what we're talking about, so often we see candidates who made these bad decisions at the age of 18, 24 years old. Most of the violations that we're talking about were related to felony drug possession, writing bad checks, shoplifting, such as those things. We're not talking about any violent type of crimes. And for that reason, I ask that you consider this legislation that would broaden the pool of candidates for working in schools.
Thank you. Thank you. Delegate Cole.
Thank you, Mr. Chairman. I'm just trying to understand what are the type of crimes, and perhaps council could answer this. What are the types of crimes that those who have been convicted of, what crimes are we going to start allowing to be employed by the schools that are not currently employed?
Mr. Chairman, Delegate Cole, generally speaking, it would be nonviolent felonies, anything that wouldn't be listed in this long list of barrier crimes, and then anything involving sexual molestation, physical or sexual abuse, or rape of a child.
Mr. Chair, may I add?
Delegate Ward.
Yes, we're talking about things like bad checks, writing a bad check, wrote a check for your rent that didn't go, or whatever. $200 would make you a felon. Shoplifting also, and sometimes drug possession, maybe marijuana, whatever. That's what we're looking at, those things that sometimes are just done in the youth, and you continue to prevent people from ever gaining any type of meaningful employment.
Delegate Cole.
Thank you, Mr. Chairman. Just follow up. Is there any time period or anything where they have to demonstrate a clean record or anything before they would be eligible for employment in your bill, or is it just whenever they get their rights restored, they're good to go?
That is the way the bill reads at this point.
Thank you.
Delegate Van Valkenburg.
Thank you, Mr. Chairman. I just want to clarify the posture we're in, so I'm kind of in my headspace here. So as it currently reads with the amendments, we are talking about people who would be employed by the school system but not volunteers, and we would be saying that they would be able to get a job with the school system if it was a nonviolent crime. That's just for clarity's sake that I'm asking.
Yes.
Yes. Any individuals here to speak in support of this legislation? Those that are prepared to speak in opposition can line up behind her.
Thank you, Mr. Chair. My name is Robin Ruth. I'm the Executive Director of Human Resources for Hampton City Schools, and I'd like to start by thanking Delegate Ward for sponsoring this bill. As she stated in her remarks, the impetus for this bill was in reviewing the qualifications to be a school board member. And currently, an individual who has been convicted of a felony crime and had their civil rights restored can run for and if elected, serve on a local school board. However, as an employer, I cannot ever employ them, nor can they work for a contracting agency for a school board. And so that started the conversation with Delegate Ward to see if we could expand the language in this particular section of code to for employees. And it's an effort to help broaden the pool, and also for young people, the vast majority of folks that we see who have a barrier crime on their application did something really dumb when they were young. And, 20, 30 years later, they're still being held accountable for that, and not able to get gainful employment with a public school division. And so we are asking that the code match more of the expectations for our elected officials.
Thank you.
Mr. Chairman, I move to report.
There's a motion and a second to report. Members will record their votes with amendments. Bill reports 5-2. Thank you, Delegate Ward.
Thank you, Mr. Chair, members of the committee.
Delegate Reed.
Thank you, Mr. Chairman and members of the subcommittee. I'm addressing House Bill 718, so hopefully that's the one that's, I know I have another bill that we're coordinating with Delegate Goditis, but
Let's go with 725 first.
Okay. 725.
And we are incorporating 1469 into your 725?
I think it's the other way around, Mr. Chairman.
Oh, okay. Well, we'll go with your other one then.
Okay.
All right. What's your other one?
The other one is 718.
Actually, let's go ahead and incorporate your.
Okay.
We'll go ahead and incorporate 725 into 1469. Is there a motion?
That's correct, sir.
Second.
There's a motion and a second to incorporate 725 into 1469. Let's voice vote. All those in favor express by saying aye.
Aye.
Those opposed? Delegate Reed.
Thank you, Mr. Chairman. So now we're looking at House Bill 718, and I do have a couple people that I know are here to speak in favor of this, and so again, I'll try to keep my remarks somewhat limited. The proposed legislation would require that an interrogation of a public elementary or secondary school student by a school resource officer must not be conducted without written consent of a parent or guardian. The reasoning behind this is that elementary and secondary school students are not necessarily prepared for interrogations with potential legal consequences, and students may not know their legal rights or understand the implications of the interrogation. Having the parents included in the discussion will provide students with added protection. Students with special needs are the most at risk for misunderstanding, and having a parent consent to a conversation that may have legal consequences is essential to protecting those who need it most. And from our estimate, there is not a fiscal impact statement. This is a particular piece of legislation that is an outgrowth of some discussions with some constituents, and also as I have had meetings with constituents and recognizing that there are even adult individuals, especially with special needs, who have encounters with the law and then are maybe admitting to things that they shouldn't be. And so especially for children of this age, we need to be sure that we have parental consent involved so that they can know what potentially they're admitting to or what the discussions could have legal consequences. So that's the purpose of the piece of legislation, Mr. Chairman. And as I said, I know that there are a couple people that are here to speak about it, but I'm
Anyone here
open to
that
questions.
speak on in support? Anyone here to speak in opposition can line up behind her.
All right. Good afternoon, Mr. Chairperson and members of the committee. My name is Catrice Nolan. I'm a parent in Loudoun County Public Schools, as well as an engineer and a business owner. I'm here to speak in support of this legislation. Like other counties in the state and Loudoun County, we have significant disparities in both discipline as well as referrals to law enforcement when it comes to both minority children and children with special needs. Although Black and Hispanic children make up 6.3 and 16.2% of the population respectively in Loudoun County Public Schools, they were referred to law enforcement at a rate of 15.8% and 31.3% respectively. I support this legislation because parent permission is required to administer medication and to enroll in school. So if we want to ensure that we are not pushing various disparities on our student populations, then we need to make sure that the children have the requisite support from their parents to ensure that what questions are being asked, they appropriately understand. And so we support this legislation today, or my family does.
Thank you.
Hello, my name is Sharon Trofe. I am a Loudoun County citizen. Thank you for allowing me to speak with you today. We are here. I also serve as in the capacity as the SEAC chair, which is the Special Education Advisory Committee for Loudoun County. In that capacity, we report to our school board the unmet needs of students with disabilities. I would like to share that we support this legislation because our students have a diminished capacity to fully understand any implications that may be coming before them. A lot of our students have difficulties with understanding social cues and being able to read and understand the perspective of others. So often they may say things that they think the adult may want to hear versus actually fully understanding what is occurring. Many of our parents will write letters to the school and put letters in their files requesting parents be present if discipline matters ever occur. However, the school division has no responsibility really to follow those. So we are in support of this legislation, especially for students with disabilities that have a parent present if they are ever questioned by a resource officer.
Good afternoon, Mr. Chairman, delegates. My name is John Mahoney. I'm with the Virginia Association of Commonwealth Attorneys, here to speak in opposition to this bill. Over the years, we've gone to great lengths to get resource officers into the schools, and now we've got a bill that wants to tie their hands. I can tell you from personal experience, years ago when I was an assistant Commonwealth attorney, I had the resource officer call me anytime there was something involving multiple students at the school. We'd talk to the students. They'd have somebody in, by the definitions of this bill, in custodial interrogation. But we'd get the problem cleaned up in very short order. And then I'd go back to my office and wait for the phone to ring. And invariably, it would ring with angry parents. Why did you talk to my child? I said, because there was an incident at school. I'd give them a little bit. They said, well, you didn't call me. I said, ma'am, I didn't have to call you. And the response I would get would be, I wouldn't have let my child talk to you. And I'd say, yes, ma'am, and that's why I went and talked to your child. Parents aren't going to let their kids talk. We've got situations in schools that can be very dangerous enough in schools that we've put resource officers in there to keep children safe, and we need to let them do their jobs. And I would suggest that resource officers aren't going to lock a child in a room and just go at them like you see on TV with an interrogation. Anything in the school could be considered a custodial interrogation if the officer stops the child to ask them questions. And that's going to create many, many, many motions to suppress evidence.
Thank you, sir.
Okay, thank you.
My name is Will Shaw. Live in Louisa County. I don't represent any group. As I read this bill, I'm afraid it would interfere with just about a lot of what the school resource officer does. It would pretty much eliminate any informal conversation because just about everything could be construed to be a custodial interrogation. And got major reservations about this bill. Thank you.
Thank you. Not seeing any questions from any members of the committee.
Mr. Chair?
Mr. Chair, I do have a
Delegate McQuinn.
question. Thank you, Mr. Chair. Delegate Reed, just several questions. At what point, I guess, does the administration sort of have the interview when there are incidents in the schools, and at what point does the resource officer steps in?
Delegate McQuinn, I will ask if one of my
Phone a friend.
yes could help with that.
Can you repeat that?
Yeah, I wanted to ask the question, at what point does the administration, when there's an incident that happens in the school, the administration takes the responsibility and, interview the students to just have a sense of what went on? And so what point does the administration do their job or what they do, and then the officer or resource officers are allowed to step in? Is there,
Currently, the MOU would define that.
Okay.
We're in the process of, in Loudoun County, finishing or working on the MOU, trying to follow the procedures to obtain community input. So we don't have a ratified one currently where it's in process. But in the draft MOU, some of the community concerns, we feel that there's not a clear distinction for that question. In looking at different jurisdictions, we found that other counties did have a clear distinction of where the school division and the principal and administrative staff are responsible for enforcing school rules and school discipline, and the SRO officers would only step in when it became a legal matter. So really that is a MOU issue.
Mr. Chairman, Delegate McQuinn, Stacey Haney with the School Boards Association, and actually the last point the speaker made was basically correct, that generally the school administrators and principals would be and should be questioning students related to incidents that are disciplinary, school-based discipline incidents. School resource officers should be questioning students only when you get into the realm of something that may constitute a criminal infraction. Of course, there's other legislation up later today in this committee about reporting to law enforcement, but so that might change, but that's really the distinction is if we're talking about criminal conduct, then the SRO may get involved. If we're talking about code of conduct, the school principal or school administration should be handling the matter.
Okay, thank you, Mr. Chair.
Mr. Chair?
Yes. Delegate McQuinn.
Yeah, Delegate Reed.
Yes.
So I'm trying to understand if this is put into law and there's a violation by the resource officer or the school allowing them to do that, then what is the penalty?
And that's a good question, Delegate McQuinn. Currently, there's nothing written into this particular piece of legislation that would actually create some type of penalty for the school resource officer. Rather, instead, as the other two speakers had identified, that there would be this additional guidance or guideline that says the school resource officer cannot actually have those legal discussions without first getting parental consent in advance. And again, this is really intended, and I will give you as an example for Loudoun, I don't know if the number is the same across all the different jurisdictions. Of the 80,000 students in Loudoun County, about 10% of them either have an IEP or are identified as being special needs. So it's intended to make sure that those individuals are not self-incriminating themselves when they are going and having discussions with the school resource officer, as well as the other witness had identified that there is a higher preponderance of sending both African American and Latin American children to legal recourse in the event that they are sent to the school resource officer, disproportionate to their actual population in the school system. So this is a early stage effort at trying to kind of break that school to prison pipeline of making sure that children are not actually admitting to things without having their parents present and then getting referred to long-term legal issues.
Delegate
Yes.
Van Valkenburg.
Thank you, Mr. Chairman. So I think what makes me uneasy about this bill, because I think I support the spirit of it, I think what makes me uneasy about this bill is it gets into that tricky place where you're talking about MOUs, where what is the proper response, or what is the proper job of a school administrator, what is the proper job of law enforcement? And over the last couple of years, we've been having that conversation, as was referenced with some of the bills that are going to come forward in the last block. And I don't think this bill does a good job of kind of separating those differences out, because 9 times out of 10, what's happening is you have a school resource officer and an administrator in the same room as a child, and this bill says, where is it? On line 15, it says, in such circumstances that would lead a reasonable person to consider himself to be in custody associated with arrest. And
Delegate Van Valkenburg, let me stop you there. What we're going to do is ask for this bill to go back for the day. And folks in the audience, this is probably the only bill we're going to have to go back for the day. And we're going to ask those individuals that have concerns with the bill, as you have read it today, to go and speak with Delegate Reed and see how we can make this bill better. Is there a motion?
So moved.
There's a motion and a second for this bill to go back for the day. All right. All those in
Chair.
favor express by saying aye. Those opposed? Thank you.
Thank you, Mr. Chairman. Thank you, committee members.
Thank you. Delegate Guzman.
Mr. Chairman, may I ask a question on the last bill? Is this going to come back up again for discussion? I wanted to speak and I didn't get a chance.
Yes, and it'd probably be better if you have some real concerns with it to see Delegate Reed before our next meeting. We'll probably have a couple bills on there, but it'll be a very small agenda. For hearing that testimony, it made me understand why we need that bill. Delegate Guzman.
Mr. Chairman, I would ask that House Bill 897 could get rolled into 271.
Um,
271, what? 292, sorry.
Can we do,
Because 897 is on the screen, that's why I was.
can we do 1081 first?
Okay, if 1081
We'll do
could
1081
pass
first.
by for the day, because one of the testifiers had an emergency, I had to leave. I apologize.
That's going to be rough for us. That's going to be rough. You can't present your bill without them?
I think I. Okay, yeah, if you want to bring the.
I'll get the binder.
You can speak to? Okay.
I think you should present your bill.
Yeah, so let me bring my file there. You have it there? Okay. Hold on 1 second.
We'll take care of Floyd while you all work on that.
You're going there then.
We'll take care of Floyd while you all work on that. Delegate Carol Floyd.
Thank you.
First, can I get a motion to incorporate 1169 into 365? There's a motion and a second to incorporate 1169 into 365. All those in favor express by saying aye. Those opposed?
Keish, is there an amendment?
Thank you.
Is there an amendment?
Let's do 365 first.
365.
365.
Thank you, Mr. Chairman and members of the committee. Members of the subcommittee, I'm here to speak about House Bill 365. This bill is simply to remove language that gives local school boards the discretion of keeping teachers on probation for 5 years and ensuring that no probation is longer than 3 years. 5 years is one of the longest probationary periods for teachers in the country. 35 states in the country have 3-year probationary periods for teachers. Before 2013, Virginia also had a 3-year probationary period, and it was extended in 2013 to 5 years. We're asking that it be changed back to 3. We need teachers and school boards to have finality and understand that there is due process after 3 years of a teacher being hired. Virginia is one of only a handful of states that can deny a teacher's due process for up to 5 years. This is an excessively long time. And frankly, denying their due process for 3 years is still long according to best management practices. Research indicates that best practice is a period of probation of no more than 6 months. School leadership should be able to determine within 3 years whether or not a teacher is a good fit for their school and division. 3 years also allows for the full implementation of a thoughtful and effective mentoring program to support any new teacher. And to be clear, the code grants wide reason to terminate any teacher. It is not, quote unquote, hard to fire a teacher in Virginia. Under Code Section 22.1307, dismissal of a teacher grounds, teachers may be dismissed for incompetence, immorality, noncompliance with school laws and regulations, disability, conviction of a felony or crime of moral turpitude, and there's a catch-all, any other good and just cause. This bill is about restoring due process for teachers, and this bill restores consistency of 3 years, thereby leveling the playing field for all teachers in all school divisions, because different school divisions do have different times for probationary periods, some 3, some 5. What we're asking for is 3 years across the board, and I ask for the committee to report this bill.
Those are the board. Mosley?
No, sir, I'm sorry.
Members here, individuals here to speak in support. And I'm sorry, I didn't mention it earlier, but we're going to limit it to 2 minutes for those individuals speaking in support, and 2 minutes collectively in addition to that for individuals speaking in opposition.
Mr. Chairman, members of the subcommittee, I'm Kathy Bircher with the Virginia Education Association. This is actually a top legislative priority this year for the Virginia Education Association. We're grateful to Delegate Carol Foy for carrying this, and we were actually equally as thrilled to see Delegate Wampler carrying this legislation as well. I had a good conversation with him about the need to restore the 3-year probationary period to ensure that teachers after 3 years have due process. This is not about changing any reason for which a teacher cannot be fired. It's just about ensuring that the 3-year period is over. Teachers are then at that point granted due process. 3 years is an extraordinary long time to be on probation. Classified state employees have only a 1-year probation. In my job, I had 45 days. I feel like I'm good at my job, but on day 46, I was like, woohoo, I'm no longer on probation. This is about due process for teachers, and we urge you to support the legislation.
Mr. Chairman, Stacey Haney on behalf of the Virginia School Board Association. We have some concerns with the legislation. When the probationary period was changed in 2012 or 2013, what the legislation did then was give school boards the option to extend from 3 years to 5 years. The reason behind that at the time was that we had a lot of superintendents and school administrators who had teachers at year 3 who were on the bubble, and they weren't sure whether they should keep them on or non-renew them. Under the old law and under the law, if this bill passes, at year 3, it's up or out. And what I would suggest to you is that if you have teachers on the bubble and this bill passes, they will be non-renewed, and instead of giving them an additional 2 years to demonstrate proficiency. And so I really think that this is going to be cutting off one's nose to spite one's face. And I think that it's going to have a negative impact. And so I would just caution you.
Mr. Chairman, Tom Smith, the Superintendent's Association. We also have concerns about this bill. You also have to remember that when we set up this 3 to 5 year process, there were a number of things that were linked to it. And one was extension of the provisional license from 3 years to 5 years with a recommendation of a superintendent. So we think that as Ms. Haney indicated, this is sort of going to be a domino effect and will actually hurt teachers more than assist them.
Mr. Chairman, members of the subcommittee, Bette Neal with middle and high school principals. We do support due process for our teachers. However, we are concerned this, as you've heard before, that this could harm some of our teachers who are, as you've heard, are on the bubble, and we do not think that should be non-renewed, but that could be the result. Thank you.
If I may, Mr. Chairman, address the concerns. So I completely understand about the 3-year teachers' probationary period being quote-unquote on the bubble. However, there is an option to have a continuing contract. So it's not that you get to the 3-year period and you're automatically terminated. That's not what happens. If there's a school district that has a talented teacher, but there may be some opportunities there, then that's where the opportunity kicks in to have mentorship and to have meetings and classroom control, whatever needs to happen in order to bring that teacher up to par. So to say that all teachers that's right there 3 years, if we pass this legislation, will then be fired is incorrect. There are other options and avenues, such as continuing the contract to give that teacher opportunity to build up their talents and their strengths and become better, so where they can be permanently hired.
Mr. Chair. Just a question or comment coming from administrative part of a high school principal. I concur with those who spoke against it. I think it is a detriment to teachers. I know what happens after 3 years. I'd rather have the option, with all due respect, to work continuously 2 more years with the teacher for self-improvement with a self-improvement plan. The case is, at the 3, it's cut. And that's my concern. I do agree that it may be a detriment to teachers whom we're trying to help for remediation and to improve their instructional ability and delivery of instruction.
Mr. Chairman, move to report.
There's a motion to report. Is there a second? There's a motion and a second to report. All those are expressed by members will record their vote in just 1 moment. Now. Bill reports 4-3. You have another?
Yes, Mr. Chairman. I also have,
368.
yes, Mr. Chairman. House Bill 368, Public School Enrollment. What this bill does is it allows for foster children, some of our most vulnerable children who have suffered through trauma, abuse, and neglect, to be able to continue to attend their homeschool up to the age of 22. Right now, the code allows for a child to continue their schooling, hopefully to get their diploma, until the age of 18. However, the statistics are clear that when a child has suffered through the amount of trauma that usually foster children encounter, especially being a foster parent for 8 years myself, oftentimes they are delayed educationally up to 2, 3, sometimes 4 grades. And so it may take them a little longer, but at the end of the day, our goal here in the Commonwealth of Virginia is to have them receive their high school diploma. So what this bill does is allow a child to be able to be educated in their home school up to the age of 22. We picked 22 because federal law, the Individuals with Disability Education Act, requires that we have up to age 22 for children who qualify under this federal law, and an overwhelming number of foster kids actually do, along with having IEPs and other needs. So there is no additional monetary benefit. There's no additional foster care benefit. It simply allows a foster child to be able to go to their home school up to the age of 22, and the code already allows for up to age 18.
Any individuals here to speak in support? Those individuals here to speak in opposition should line up behind them. And again, 2 minutes on each side.
Mr. Chair, committee members, Amy Willard with Legal Aid Justice Center. I think this is a pretty simple bill. Back in 2011, we actually codified some federal protections for youth in foster care to provide for educational stability, because we knew that kids in foster care, as they changed foster care placements, were having to change schools multiple times. It simply established a collaborative process between the Department of Social Services and the Department of Education to sort of assess what was in the best interests of children in foster care. Should they be able to stay and continue in the school that they've been going to, or perhaps change to the school where their new placement might be? That was simply for youth in foster care, which technically ends at age 18. Since then, you all have done tremendous work to actually help our young people who have aged out of care. But those young people who've aged out of care at 18 may still be pursuing their high school diploma. What this bill does is simply extend some of those stability protections all the way through a young person's K-12 lifetime, so that if we have a senior whose age 18 turns 18 while in foster care, their foster placement or their new placement might be in a different division, but it would allow them to continue to finish out their senior year in their same school and keep some of that stability in place. We know youth in care have a lot of trouble with credit transfer, all of the kind of instability that comes from changing schools, and this just opens up some options without necessarily expanding benefits or anything of that nature. So we hope you support the bill.
Good evening, Mr. Chairman, members of the committee. Valerie LaRue from Virginia Poverty Law Center. We also support the bill for the reasons already stated by Ms. Willard. Thank you.
Mr. Chair, members of the committee, Allison Gilbreth with Voices for Virginia's Children. We also support this bill.
Mr. Chair, members of the committee, Cassie Cunningham with Children's Home Society, and we also support the bill.
Anyone here to speak in opposition?
Mr. Chairman, I apologize. I have an amendment in the nature of a substitute that I forgot to move.
That's a motion.
Move the amendment.
There's a motion and a second to move the amendment. All those in favor express by saying aye. Aye. Thank you.
Yes, and if I may speak to the substitute reflects the recommendations given forth by the Department of Education. What it does is simply move it to a different code section, and that's it.
Thank you. Thank you. I think that's pretty clear. There's a motion and a second to report. Members will record their votes. Excuse me. There's a motion and a second to report and refer to appropriations. Members will record their votes now. Reports and refers on a 7-0 vote.
Thank you, Mr. Chairman, members of the subcommittee.
Next one. Tab 4, you have two more. You did it, not me.
See.
836, micro credentials.
Yes. Yes, Mr. Chairman, House Bill 836, micro-credentials. Before I begin, Mr. Chair, I would like to move an amendment in the nature of a substitute.
Move the substitute.
There's a motion and a second to move the substitute. All those in favor express by saying aye. Aye. Those opposed? Delegate Carol Ford.
Go ahead.
Yeah, Ms. Ma'am.
Thank you, Mr. Chair. In 2019, the General Assembly passed Delegate Jeff Bourne's House Bill 2217, directing the Virginia Department of Education to allow micro-credentials for K-12 teachers seeking to teach in high-need STEM subjects. In the summer of 2019, the Virginia Department of Education convened an advisory board to develop recommendations for perimeters around how micro-credentials should be established. What emerged were the recommendations from this fall. The micro-credentials are an innovative and essential new tool in teacher licensure and certification in that they provide high caliber but low cost and customizable alternative to other expensive teacher development programs. Micro-credentials typically aim to provide education and qualitative assessment of discrete areas of distinct domain knowledge in the areas of teaching to specifically assess a teacher's knowledge and the subject content and their ability to effectively present their content. With the high cost of education and the teacher shortage that we are feeling throughout the Commonwealth of Virginia, this is a cheap, viable, and high-quality way to ensure teacher competency and continue professional development in subject areas. It is my ask that the subcommittee report this bill.
Seeing no questions, is any individuals here to speak in support?
Mr. Chairman, members of the subcommittee, Kathy Birch.
Those individuals that want to speak in opposition can line up behind them.
With the Virginia Education Association, I've learned a lot about micro-credentialing in the last year since this bill, the initial bill, was before you last session. I actually served on the committee that reviewed these recommendations. There's a whole lot out there in the land of micro-credentialing, and so what this bill will do is ensure that these are high-quality credentials that can be applied towards recertification points, and so the VEA supports the legislation.
Mr. Chairman, members of the committee, Randy Pearson on behalf of Code VA. We thank the patrons for bringing the bill forward and would ask that you act favorably upon it. We are working on some potential amended language to help reduce some concerns about fiscal impact. That's not ready yet. We are working with DOE and the patron on that language, but we would ask you act favorably upon the bill today. Thank you for your support.
Mr. Chair, move to report and refer to appropriations.
Second.
There's no
The substitute.
there's no letter with this.
Oh, all right. I will move to report the substitute.
There's a motion and a second to report the substitute. Members will record their votes. The substitute reports 7-0. Want to try one more?
Yes, sir.
Test your luck.
Thank you. House Bill 837, Dress Code Equity Act, guidelines for policies for dress and grooming codes in Virginia. Back in November, I hosted a listening session with the National Women's Law Center with African American girls from across the Commonwealth, where they spoke about the issue that they're having, specifically also in Richmond, where African American girls are being pushed out of school. The difference between being pushed out and suspended is that suspension is formal, push out is being asked to leave and not return until you're in compliance with the dress code. Some of the times where they were not compliant were because they had braids, dreads, head wraps, cuts in their jeans. Girls of color, and particularly black girls, are pushed out of school at a rate of 5.5 times higher than white girls by discriminatory discipline. Unnecessarily strict and harsh dress codes are fueling those numbers. Virginia students have been vocal about the impact of discriminatory dress codes on their education and have asked schools to adopt more equitable and inclusive policies that's respectful to individuals' racial, ethnic, cultural backgrounds. House Bill 837 directs the Board of Education to establish guidelines and develop model policies for codes of conduct to help local school boards implement fair and equitable dress code policies. I am open to answering questions that the subcommittee has, and I ask for it to be reported.
Any individual here to speak in support? Any individuals here to speak in opposition? I think you got 1, 2, 3.
Good evening. My name is Adaku Anyeka Crawford, and I'm from the National Women's Law Center. When we talk to girls across the country about the things that make them feel policed in school, the thing that keeps on coming up and the thing that Delegate Carol Flory mentioned is dress code enforcement. It's teachers commenting on their body parts or principals saying that when a girl dresses a certain way, they're inviting harassment. These messages stick with young people. It teaches them to be ashamed of their bodies and to blame themselves for any harassment that they suffer. This bill has the potential to change the messages that all students in Virginia get in school. It balances guidance that allows districts to have the flexibility in their policies while implementing common sense restrictions like prohibiting staff from physically enforcing dress codes or subjecting students to public humiliation by requiring them to undress in front of school staff. We urge you to vote favorably on this bill and send the message to Virginia students that they are respected and valued in their school, no matter their race, gender, or appearance. Thank you.
Hello, everyone. My name is Kirsten Brockenborough, and I'm here from the National Women's Law Center. And I'm ecstatic, actually, to be here because I am a product of Prince William County Public Schools. So thank you. 10 years ago, I was essentially harassed by both my classmates and my teachers and essentially sent into in-school suspension. Unfortunately, this is a reality for Black girls who look like me today. And hopefully, with your support and encouragement, we can change this. Again, this is less than 10 years ago. Thank you.
Mr. Chair, committee members, Amy Woolard with Legal Aid Justice Center. For the reasons very aptly stated, we support the bill.
Mr. Chairman, Todd Gackey with the Family Foundation. We're opposed to this bill. We think that this is an issue that's best left for the local school divisions, and that creating a mandated statewide policy is not really in the best interest. That local school districts are best equipped to handle these situations. And quite honestly, this could be a solution in search of a problem. It could have unintended consequences. So we would ask this body not to report this bill.
My name is Will Shaw from Louisa County. I have a concern with one aspect of this. The portion that says maintain gender neutrality by subjecting any student to the same set of rules and standards regardless of gender. This kind of ignores basic fundamental differences in anatomy. And I think the local school division can handle this better than that statement. Thank you.
Delegate Avoli.
Yeah, Delegate Carol Flory, why not let the local school boards deal with this?
Because they have failed to address the issue.
Do you agree that we should have a dress code in high school or middle school of some sort for, I've had to administer this. I can tell you, walking in the principal's shoes and having to deal with a lack of a dress code for all, equality for all, and equal for everyone, does create a tremendous, tremendous problem.
I believe that there should be a dress code. However, it should not be based upon terms such as appropriate or things that leave it so open that it's subjective to where you could have two different principals having disagreements about what is appropriate and what's not, and not actually respecting people's racial, ethnic, and cultural differences. I think as a Commonwealth, we are evolving to understand that while white people may not ever wear dreads, Black people do. And that is not reasonable for someone to say that is unkempt or unprofessional and you should not wear your hair that way. That leaves a door open to subjectiveness where you have certain class of individuals that's targeted and seeking the brunt of that type of subjective policy. So that's what we're seeking to eliminate.
Delegate Rasool.
Mr. Chair, I think the bill goes on to talk about that it should have a school, should have a code of conduct, and then it talks about what should be in that dress code. And lining this up, unfortunately, we've seen it's tough finding the balance here. But we've seen the abuse of this, especially with regards to cultural, ethnic dress. I think it's time for us to make progress. I know a number of folks have questions on the exact language, for sure, but I think it's time for us to be able to move on culturally and otherwise. So, Mr. Chairman, I would move that we report the bill.
There's a motion. Is there a second? Second. There's a motion and a second to report.
There is.
Members will record their vote. Bill reports 4-3. Thank you, Delegate Carol Ford.
Thank you, Mr. Chairman. Thank you, members of the subcommittee.
Delegate Guzman, are you ready?
Yes.
Thank you, Mr. Chairman. House Bill 1081, I would like to present substitute, an amendment in the form of a substitute.
Thank you. We're ready. Is there a motion? There's a motion and a second. All those in favor express by saying aye.
Thank you, Mr. Chairman. Members of the committee, House Bill 1081 will authorize school attendance officers to file form petitions and motions for the enforcement of orders entered by the Juvenile and Domestic Relations Courts in response to the filing of an initial petition for a child in need of supervision under Virginia's compulsory school attendance laws. It's a very simple amendment precipitated by the large number of students who are chronically absent from school and the concern that filing and post-filing of these petitions by school attendance officers may violate the unauthorized practice of law. I think we all watched the presentation where we see that one of the causes for students not succeeding in schools is due to the the amount of absence. Last year, there were at least 583 court appearances in the Prince William County Juvenile and Domestic Relations Court for students who were brought before the court for absenteeism on these petitions. These are allowing this attendance officer will help this situation, and this situation is not unique to Prince William County. It actually poses a huge challenge for our juvenile and domestic courts, which are probably finding increasingly difficult to manage these dockets. The compulsory attendance laws, particularly in this code, and this part of the code, authorizes, indeed requires, school attendance officers to enforce the attendance laws after school-based efforts to secure attendance have failed, and to do so by either filing a petition with the Juvenile and Domestic Court for instituting proceedings against the parent. The proposed amendment pertains only to this type of petitions. These are form pleadings approved by the Virginia Supreme Court, particularly the form DC 511, which is the form used by attendance officers to file for both the original petitions and subsequent petitions or motions contemplated by the amendments. As with the filing of the original petition, the filing of any subsequent petitions or motions intended to enforce the court's order would also go through the court intake officer. The intent of this bill is to authorize attendance officers to file the same or similar form petitions after the court has entered orders on the original form, in situations where it's necessary to bring the student back before to the court.
Thank you. Any individuals here to speak in support? Individuals that are here to speak in opposition, please line up.
Mr. Chairman, Stacey Haney on behalf of the Virginia School Boards Association. This legislation was brought at the request of the Prince William County Public Schools, who their representative wasn't able to be here today. We also support this legislation. It's a particular problem in Prince William County, but it's not only in Prince William County. The issue is, and this is a really simple bill, the issue is that there are some J&D court judges who say that attendance officers can't file these petitions, and they take the position that it must be an attorney who comes and files these petitions. And so in Prince William and other school divisions, they're having to send an attorney instead of an attendance officer. Attendance officer is somebody who already exists in the code, who does all these other functions as it relates to student attendance, but then the school divisions are being forced to hire their attorney to come and handle these petitions. It's something that an attendance officer can absolutely do, and in some school divisions, they do. And so it's a really simple bill that just allows the attendance officer rather than the attorney to have to do it. And when you have a school board attorney up here telling you, let a non-attorney do something that they would otherwise have to pay their attorney to do, I would suggest that it's a really good idea. It just simplifies things for school divisions, so I would ask that you support the legislation.
Thank you so much.
Mr. Chair, I move to report.
There's a motion. There's a motion and a second to report. Members will record their vote. Excuse me. Yeah.
With the amendment.
As a substitute.
Moves.
I move the substitute.
There's a motion and a second to report the bill as amended. We adopted it first. There is, you meant to vote that way, right? No, you mean to vote that way?
No, I did not mean to vote that way. Thank you.
There's the bill reports 7-0. Delegate Kilgore. Oh, I'm sorry. You have one more. You have another one.
Yes.
Yeah, go ahead. I'm sorry.
But I can let Kilgore go.
Okay.
Yeah. Go ahead.
Hopefully mine will be pretty quick. Mr. Chairman, ladies and gentlemen, House Bill 1630. And House Bill 1630 came to me from the Lee County School Board, and what it does, it prevents school board and any division superintendent to extend from 3 months to 6 months the period in which a provisional license of an individual seeking his or her initial teacher license who has not completed a professional assessments will expire for that purpose, as long as they have passed a mid-year satisfactory mid-year performance review in the current year and meets all other eligibility requirements. This would help with our teacher shortage in Southwest Virginia and would allow those individuals to continue to keep moving toward their teacher licensure. So just move it from 3 months to 6 months. It would be at the request of the division superintendent or the school board.
Any questions, members? Any individuals here to speak in support? Any individuals here to speak in opposition can line up.
Chairman Tom Smith, the Superintendent's Association, Superintendent's Association, we are in support. This is trying to figure out a time frame hole in what we've been doing. If you remember, we did have legislation last year that would allow superintendent to recommend continuing on a provisional standard, and so this is just another part of that process.
Thank you. Seeing no other individuals here to speak in opposition for or in support or opposition, members?
Move to report.
There's a motion. There's a second. Members will record their vote. Reports 5-0.
Thank you, Mr. Chairman.
Thank you. Delegate Rush?
Thank you, Mr. Chairman.
Go ahead. No, go ahead.
Okay. Thank you. First bill I have is technical professional license for military science. This bill was brought to me by the Montgomery County School Board. Montgomery County started their own Corps of Cadets throughout the Montgomery County school system, and it's not a junior ROTC, so the state board only recognizes licenses that the junior ROTC does, which has made it very difficult to get instructors. So what this bill would allow is the state board or the local school board to set the criteria to have military science instructors, much like you would, say, a technical profession like welding or cosmetology or something like that.
Okay. Members, any questions? Anyone here to speak in support? Anyone here to speak in opposition? Members? There's a motion and a second. Members will record their vote. Reports with a 5-0 vote. Next bill, sir.
Want me to do that? Let me go ahead and do that next one.
Yes, sir.
Thank you, Mr. Chairman.
If that's your pleasure.
Yes, Mr. Chairman. House Bill 710 allows the national motto.
Actually, let's hold off on that one.
Okay, you want to go by for the day?
Is that what you want to do?
Yeah, I have to go to another. I've got another
Okay.
bill.
All right, we'll go back for the day on that
All
one.
right. Thank you, Mr. Chairman.
Delegate Edmonds.
Move 710 by for the day.
Thank you, Mr. Chairman.
Oh, yes, I'm sorry. Make that motion again, please, sir.
Move that 710 go by for the day.
There's a motion that 710 go back for the day. Is there a second? Second. All those in favor express by saying aye.
Aye.
Those opposed? Motion passed. Yes, sir.
Thank you, Mr. Chairman.
Thank you.
Mr. Chairman, if you remember last year, and you probably do, the sales tax bill, the great sales tax bill for Halifax County, which helped us find a revenue stream to build a new high school, which, by the way, for the benefit of the membership, that bill or that referendum passed by 71%. So we're on our way. But we're still looking at a $90 million project. And it came to my attention that perhaps the best way to help borrow for this project would be to go to the VPSA. And so I contacted Mr. Maggio with Appropriations and asked what avenues schools have to borrow money for capital building projects. And currently, they may do so through the composite index ratings. But my bill, and he suggests that this is a better way because, for example, Richmond City and Chesterfield may have a favorable composite index, but not have but still be considered high or above average fiscal stress. So this bill changes the composite index criteria to use the fiscal stress criteria of above average or high. And it also allows the literary fund to be used to subsidize the 0% interest loans. So
thank you.
There is no fiscal impact, according to Mr. Maggio.
Well, we just we did get a letter for this. Am I correct? Yeah, we did get a letter. So if this is acted upon favorably, then we need to go to appropriations.
Okay.
Any questions, members? Any individuals here to speak in support? Those individuals that are here to speak in opposition can line up behind the gentleman.
Tom Smith, Superintendent Association. We're in support. Mr. Chairman, members of the committee, we're trying to find any way we can to help with construction and renovation, and this is one piece to the puzzle. Thank you.
You're the next contestant on the...
Stacey Haney with School Board Association. We also support the legislation.
Awesome.
Mr. Chairman, I would move to report and refer to appropriations, House Bill 1633.
Second.
There's a motion and a second to report and refer, and there's a second. All in favor, expressed by, record your vote on the electronic.
Mr. Chair, can we make this retroactive 2 years? No?
Reports 5-0.
I thank the committee.
Report and refer 5-0.
Thank you.
Delegate Brewer.
Good morning, Mr. Chair, members of the committee. How are you?
Good morning. Afternoon. Evening.
Oh, evening, yes.
Night.
I'm ready to start tomorrow. I will be brief. Mr. Chair, members of the subcommittee, House Bill 1613 before you would allow school divisions to provide a 3-year professional development plan in replacement of the current required coursework for career and technical education instructors. Right now, the code requires that all CT instructors meet professional studies requirements, include college courses in several different areas. One of my localities from my backyard, Adelaide County, is actually experiencing this with a great gift we received from a large corporate donor, and we have an incredible CT and ag program, culinary arts, and the like. Many cases, the individual who represents the greatest amount of professional experience are those who have sought professional standing through trade programs, other alternatives such as hands-on and job-embedded training. This bill would give school divisions and potential employees the opportunity to increase turnover rates and increase student outcomes. I'd also like to note that I do have my local superintendent here to give some concrete examples of why this would be effective.
Thank you. Any questions from the members?
Mr. Chair, question.
Delegate Rasul.
I think this is going in a great direction, but I'm just trying to understand the words, if you don't mind, Delegate Brewer. So can you, because you speak so fast, can you tell me?
It's dinner time.
I know, right? An intensive job-embedded 3-year program of professional development. Can you just tell me what that is?
So there's several
Examples?
actually examples, and I'll give you one. For instance, just imagine that there's a welding program in a high school arena. While a traditional collegiate degree may be effective, there's so many different levels of higher certification that are required above and beyond to be able to teach that background and content area. So that would be one example, and I think this might be a good point to maybe bring up my expert to answer that question as well.
Any individuals here to speak in support? Those individuals that are here to speak in opposition can line up behind me. Yes, sir.
Mr. Chairman, subcommittee members, I'm Jim Thornton, Superintendent of Alawite County Schools. We have spent a lot of time, money, energy working with industry leaders in the Hampton Roads area to develop and redesign the educational experience for our career and technical education students. One of the greatest barriers remains finding high-quality individuals for these programs and retaining them. And the current code asks them to take 2 to 3 courses, for example, classroom management, human growth and development. And the current procedure, they'll get a provisional license and we send their industry certifications to the state. 6 to 8 months later, we will receive their requirements as well as those 2 classes. And they've already interacted for half a year to a year with our students. We have already done professional development training with them, how to interact appropriately with high school age children, and spend a lot of time bringing instructional coaches into the classroom. And leading researchers in professional development agree that adult learning must be relevant and immediately useful. So many of these individuals that we convince to come from industry and take a pay cut, we then tell them you have to go take 2 to 3 college courses. An example.
I have a question for the
Delegate
expert,
Rasul.
Mr. Chair. So are these individuals that you would like to employ or they're currently employed? Because when we're talking about professional development, we'd be talking about folks who are currently employed, but we want to further skill them in a certain area?
These are people who are currently employed under a provisional license and future employees. Because what we have found has happened through the years. These individuals stay with us 2 to 3 years, and then they move on, and they don't follow up and take these classes, even though they are very successful. And if I can give you one example, in welding, we only had 2 applicants. We were able to hire a gentleman who's retired from Nassau Langley with 5 certifications in welding. Our welding certifications for our students went from 6 certifications in each year to 25 students certified in his first year, and this year is projected to be over 40 students certified. He's yet to take the courses and doesn't see the need. He doesn't understand the educational world, and in the business world, he's very successful with our students. We spent a lot of time and energy training him, but we would have to say goodbye to him if he don't take these courses. And we're asking that the training we provided, we can document, send to VDOE, and have this individual certified.
Okay, thank you.
Thank you. Any other individuals here?
Chairman Tom Smith, Superintendent's Association. Very simply, we're in support.
Thank you. Members? There's a
Second.
motion and a second to report. Members will record their votes. Reports on a 6-0 vote.
Thank you, Mr.
Delegate.
Chairman, members of the committee.
Delegate Hope.
Thank you, Mr. Chairman, members of the subcommittee. I have House Bill 308 before the subcommittee. Excuse me.
Delegate Hope.
House Bill 308, it simply requires the Department of Education to establish guidelines for the granting of excused absences to students who are absent from school due to mental or behavioral health, and requires any student who is absent from school due to their mental health or behavioral health to be granted an excused absence subject to these guidelines. My objective in bringing this bill, which other states are doing as well, is to really get people to talk about it and help remove the stigma that's related to mental health. This really comes at a time when mental health problems among youth especially have been on a steady and alarming rise in recent years. A study this year showed a steeper hike in reports of mental distress, depression, and suicidal thoughts among teens and young adults than in people of other ages. And this is really something that we got to wrap our heads around. Suicidal thoughts among teens age 18 to 19 increased from 46% from 2008 to 2017, and suicide attempts among people aged 22 or 23 have doubled. And this is according to a study by CDC that says that the rate of suicide increased by 56% from 2007 to 2017 among people of ages from 10 to 24. So that's a significant increase from this cohort. These people are in high school under this tremendous amount of pressure. I have talked to the department about doing this, and there's a little bit of heartburn about putting this in the code. So, Mr. Chairman, what I'd like to do is I would like to take the language that I propose in the bill and make it a Section 1 bill. I'm not looking to do anything other than get people to talk about this, and that seemed to be something that they could be okay with. And so again, we're just trying to ask the department to develop guidelines, and that will in turn create a discussion and conversation amongst the schools to have this be a valid excuse. Because look, if you're under a lot of anxiety or you're having suicidal thoughts, that should be a valid excused absence. And I just want to make sure that that message is loud and clear. And so we don't need to put it in the code. We could just make this a Section 1 bill. And I don't know if council would be amenable to doing that, but I don't want to change the language, but I just want to lift it that tells the department that they're going to create the guidelines and the rest of the language. I mean, it's pretty easy to just lift it in there, but he would tell me if I'm wrong.
I think he's about to tell you you're wrong. I'm joking.
Mr. Chairman,
Delegate Hope, yeah, I can, in concept, just convert this to a Section 1 bill as a substitute.
Thank you, Mr. Chairman. And I, other states are doing it. I know Utah and Oregon last year passed it. Colorado and Florida, they're debating it this year. This is something that, in the hopes of us trying to get a big handle on, one of the big priorities I know for this committee and the appropriators is for more school counselors and things like that. That'll be very, very helpful in helping identify the kids that have suicidal thoughts and help making sure they get the help that they deserve and they need. But this would also go a long way in removing that stigma so they talk.
Mr. Chair.
Delegate Rasool.
I would move the substitute, which turns us into a Section 1 bill that has the Department of Education establishing and distributing these guidelines and moving forward.
There's a motion. Is there a second? There's a motion and a second. All those in favor express by saying aye.
Aye.
Those opposed? Any individuals here to speak in support?
Mr. Chairman, members of the committee, Kathy Bircher with the Virginia Education Association. We support this legislation. I will tell you, as a mother of an 18-year-old daughter who about 3 months ago, I was worried about leaving her home alone. She had claimed to be sick, but I knew there was a whole lot more going on. I was grateful as a parent to be able to give her an excused absence, and just as grateful that I work for an association that allowed me to stay home and be with her because I was afraid to leave her home alone. They're under a tremendous amount of stress. We support this legislation, and we appreciate the delegates' effort to put it in Section 1, because certainly we want to make sure we keep the code as clear as possible, but we want to make sure that school divisions have good direction on this piece, on this subject. We support the legislation.
Thank you.
Mr. Chairman, Tom Smith, Superintendent's Association. Unfortunately, we do have concerns about the bill. We're sort of caught between a rock and a hard place on this one. I understand the patron's intent, but you have to understand that the state board has already established chronic absenteeism as a factor in determining school accreditation. So if this is going to increase that chronic absenteeism, we're going to get caught both ways. Now, perhaps that, the state board would eliminate that, and that would be helpful in this situation. But right now, we're caught between a rock and a hard place.
Mr. Chairman, Stacey Haney of the School Board Association. I have similar concerns to Dr. Smith. In addition to what Dr. Smith said, moving this to Section 1 doesn't alleviate the concerns. And what the patron said was, we want to have this conversation, and he wants to ensure that we're having this conversation. We already are having this conversation, and the conversation has already been had. And in fact, the board's current guidelines include the current guidelines for absenteeism and already include mental and behavioral health. So these are already things that local school boards can, we have the guidance, we can already count these as excused absences, but we have concerns about putting it, whether it's in the code or in the Section 1 bill, and saying you shall accept this as an excused absence without any limitations, without anything around that. Given the accreditation piece that Dr. Smith mentioned, we're in this tension between we have to excuse all these days sort of without limitation, and then the accreditation piece that pushes on us from the other side. So we're in this difficult spot. And I would also suggest that we're getting at this mental health crisis a lot of different ways. I would suggest that maybe this isn't the solution to that problem.
So what he is expressing in this bill, is it being practiced now or is it not being practiced?
Mr. Chairman, my understanding is that it's currently in the guidelines from the Board of Ed, and so local school boards can provide these as excused absences. And I think what we do on the ground is we look beneath that, and we're looking at other supports that are being provided to the student. We look at the number of absences that are being used to determine whether an absence would be excused or unexcused. And my concern with this bill is it sort of puts a blanket out there of here's a way to get a no questions asked excused absence. And that may or may not be the best thing that we want to do for our students who are having these issues. Particularly if we're going to increase our school counselors, we're going to be in a better position to help these students if they come to school, not incentivizing them to stay away from school. And so I just think that those are some things that we need to think about. I think the bill is well intentioned, but I just have concerns about how it's going to work in practice.
Thank you.
Emily Webb with the Department of Education. I just want to clarify a couple of things to make sure that you guys have information on where this is actually located. Our regulations governing the collection and reporting of truancy-related data and school attendance policies does have a definition of excused absence. An excused absence is the absence of an entire instructional school day with a reason acceptable to the school administration that is provided by the parent. If circumstances permit, the parent should provide the school administration with the reason for the non-attendance prior to the absence. Examples of excused absence may include, but not be limited to, the following reasons: funeral, illness, including mental health and substance abuse illnesses, injury, legal obligations, medical procedures, suspensions, religious observations, and military obligations. Expelled and suspended students continue to remain under the provisions of the compulsory attendance requirement, and absence from school resulting from suspension or expulsion may be considered excused for the period of suspension and expulsion. So this is in our regulatory language, but we do not, it is not in any guidelines currently.
Mr. Chair, question.
Delegate Rasul?
So, but there was a big may there, giving
Yes.
examples as opposed to.
Correct.
Here, there's a shall, but the department will have the latitude to be able to define however narrowly it would like what this mental health absence will be. Is that correct?
I think we would issue guidelines to local school divisions. Local school divisions take our guidelines as parameters, but are certainly often go above and beyond that. But it would be guidelines to local school divisions for them to set their attendance policies.
So again, I just want to build off of what Ms. Webb just said. I mean, there's regulations, but there's not guidelines on this. And I think if anyone's concerned about how we define this, well, it's defined in the guidelines. I'm not saying how you have to do it and which ones you count and which ones you don't count. I'm giving the school boards, the board, the complete flexibility to define this how they need to find it. And so I'm not dictating that. So I think it's important to take note what Ms. Webb was saying. They have some similar language and regulations. I want to put it in guidelines, and I'm not going to be so intrusive of saying that you have to define it a certain way. They can write it however they want to. I don't think that a lot of people are going to take up on this, but I do think it helps remove the stigma, and I do think this is just as a legitimate reason to miss than it is that you're sick with a terrible cold or the flu. And that's what the conversation needs to be more of, and less of what you just heard before by the opposition.
Thank you. If we can, yes, I'm sorry. Delegate Cole.
Yeah, just a couple of questions for the patron. It appears that there's already, provision for mental health in the current regs, and also, if your legislation passes, not to cast dispersions on students, but would the local school teacher or whoever, counselor, still have the discretion to say, I'm sorry, you're faking just to get out of class, and you need to get in class? I mean, does it take away any of the local discretion in that sense?
If the guidelines said that it would take away that discretion, then it would. But if the guidelines are written in such a way that it wouldn't, then it wouldn't. I'm not dictating what the guidelines say. I'm actually handing a pen over to the boards and say, you write the guidelines. I don't need to define them. But this is a legitimate reason. A legitimate mental health issue is a legitimate excused absence, and it needs to be part of the guidelines, not just buried in a regulation. And we may be the only people in Virginia that are talking about this right now. And so we need to produce these guidelines and let people know about it, because this is a legitimate excuse and should be.
Thank you. I'm going to ask you this to go back just for a moment. I need to work with the clerk on, with council on it. And I'll call up Delegate Poindexter.
Thank you, Mr. Chairman. Mr. Chairman, I'll be brief. This is a very simple bill. The issue is assigning homework to students where they do not have anything better than DSL at home. The bill comes to me, it came to me last year and the year before from parents. It's going to come next year, I guess. One of the counties I represent is the 7th largest. We have 2 libraries in the county. Parents have to drive a long ways. It's simply not fair for the rural students to be assigned homework when they really have no practical way to use the internet at any reasonable speed. There's a limitation on what they can attain from an educational perspective. Libraries are a possibility sometimes. There's a cost to schools to stay open. There's conflicts in families. So it's really not a good solution, anything other than I guess, try to put our put our money where our mouths are, and I did that. I filed a budget amendment that would actually double the amount of spending for rural broadband that the governor proposed. So that's simply the bill. It's straightforward. It says don't assign homework unless the students have reasonable broadband service at home.
Delegate Avola?
Thank you.
Any individuals here to speak in support? Any individuals here to speak in opposition? Members?
Mr. Chairman, Stacey Haney, School Board Association, I don't actually, I'm not, I don't mean this as opposition, but it just occurred to me that the bill says that when the student lacks meaningful access to an internet connection, and I apologize for not bringing this to patron earlier, it just sort of occurred to me that might be a little bit more ambiguous than we really want to be.
Would your recommendation be to strike meaningless? Meaningful, I'm sorry.
I think that might make it better. Again, I'm not trying to do harm to the bill, and I can certainly speak with the patron in between now.
No,
and
what you're sharing is meaningful.
full committee, or meaningless. I mean, but so what I think, what my concern is, we don't want to create a situation where a student, the dog ate my homework kind of a situation where a student comes in and says, well, my internet was down or whatever. And I don't think the patron, and I don't think the intent of the bill is to create ambiguity. So I think if the subcommittee decides to advance the legislation, I'd be happy to try to work with the patron. I'm not trying to slow things down. I just didn't want to.
Yeah. Well, we want good bills, and so just we want to ask the chairman, what if it said something to the nature of I'm sorry, Ryan. What if it said something to the nature of, and Brian helped me out as well, verified lack of access?
Mm-hmm. Yeah, the parents can attest to that, whether they have it or not. Absolutely.
Mr. Chair.
Delegate Rasul?
How do we, question for the patron, I'm very sympathetic to the cause here because it is difficult out in the western part of the state, especially to get the right access. The first question that's going to come up is, well, we did homework before there was even the internet, and I don't know how I would respond to that.
It's not my bill, so I'm not going to respond, but I want to.
No, I couldn't hear Delegate Russell.
As you can tell, I like your bill, but Delegate Poindexter?
Well, I'm here just to try to help the kids. That's my goal. The organizational stuff and things like that is not my concern.
Yeah. Delegate Mugler?
Thank you, Mr. Chairman. Question for the patron. This sort of presupposes that teachers would know that students lack access. So the wording of this bill is a little bit vague for me. And again, back to the language of meaningful access, but it really doesn't say that. Would schools be required to do a monthly census, or how are they going to manage to figure out who has access and who does not? I think school divisions are interested to know what this is going to mean for them to have to do.
Yes, that's a good question. In your suburban areas, the school boards and the teachers really have nothing to do. It's really just in the local schools, and obviously each superintendent or school board would probably address it a different way. Some of the things that probably happen would be that the superintendent through the principals would set up some kind of local policy to query the students, say, do you have broadband at home, do you not? That's part, there's also, every time we start school, information is sent home to the parents at the beginning of the school year, and that would be in there for them to respond. So I would expect each school board would probably have their own local policy to deal with that.
Delegate Poindexter, I've offered one amendment, and Ryan's going to kill me because I'm going to offer one more. Or I'm not going to offer, but I'm going to throw it out there so someone else can offer it. And that is to change the shall into a may. And then we can work on it in the off season and come back with a shall that is
Yeah, that sort of doesn't really solve the problem, but it helps.
It's a Band-Aid until next year.
Anything I can do for the children is why I'm here, Mr. Chairman.
Poindexter loves the kids.
Mr. Chairman, I move that amendment, shall to a may.
There's a motion and a second to move the amendment. Excuse me, is there a second? There's a motion and a second to move the amendment. All those in favor express by saying aye.
Aye.
Those opposed? We did not move the first amendment, but is there appetite from the committee to move that amendment? Would you read it for me, Ryan? I'm sorry.
Mr. Chairman, and you can correct me if this is wrong, but I think the amendment was on line 62 after student lacks, strike meaningful, and then on the same line after internet connection, insert comma as verified by the student's parent.
That was my intention, but I will. We have a motion, and is there a second? Second. We have a motion and a second to move the amendment. All those in favor express by saying aye. And then you can come on up if you want to speak to it.
Mr. Chairman, I think that the first part that Ryan read, the striking meaningful, gets at the issue. I think the verified by the parent might go farther than we want to go and cause us some additional complications. Because I think we can address, in the policy, we can address how we know or don't know that the student lacks access without creating a reporting requirement that.
What do I do, Ryan?
So,
Can we strike?
Mr. Chairman, if you want to just consider those amendments separately and accept one of them and not accept the other one. So it would be striking meaningful, and then the second one would be as verified by the student's parent. So just consider those amendments separately.
Okay. So there's a motion to amend striking meaningful. And there's a second. All those in favor express by saying aye.
Aye.
Is there a motion for the other? Hearing none. Delegate Poindexter.
The second amendment was to strike meaningful. And there was
So what we did was, one, we changed a shall to a may.
Yes.
And then the second thing we did was to strike meaningful.
Sure. I'm okay with that, Mr. Chairman. I appreciate support
Are
for the
all
children.
hearts and minds clear on that? Thank you. If there's no additional discussion, I will entertain a motion. There's a motion. There's a second. Members will record their votes. It reports as amended on a 5-1 vote.
Thank you, Mr. Chairman, members of the committee.
Thank you.
It's all for the kids.
I don't want you to ever forget this moment. Delegate Tran.
Hello, Mr. Chair, members of the committee. I'm here for House Bill 1208, and we have a substitute, council can help out.
Thank you. Is there a motion? Is there a second? Is there a second?
Martha.
Is there a second?
Second.
There's a motion and a second to move the substitute. All those in favor express by saying aye. Ayes 2, no 0. Delegate Train.
Thank you so much, Mr. Chair. And when we put the bill draft in, I think the language was still really broad, so we worked with council to help tighten up the language. And let me just describe the situation, and so that the substitute helps to address it. The situation was brought to light by a constituent of mine who has 2 children, one who has lots of different medical conditions that require significant care in the mornings. She lives just outside of where the bus zone is for our area, and so she doesn't qualify by virtue of that for the bus. And so her child, who doesn't have medical conditions, she has a very difficult time transporting him to school because she's caring for her child who has medical conditions in the morning. And so this bill is just to ask school boards to establish a process, those school boards that already offer bus transportation, to establish a process for those students who reside outside of the distance that's required by the school board to be eligible for school bus passes, to ask for a waiver on a case-by-case, space-available basis for a seat on the bus if their parents have to care for a family member living with them in the house because of a medical condition that's been kind of affirmed by a physician that prevents them from transporting their child to school on time, so that child can make it to school on time and learn with his or her peers.
Thank you. Members, any questions? Thank you. Any individuals here to speak in support? Individuals here to speak in opposition? Thank you. Members will record their vote on the
Mr.
election.
Chair, I'm sorry, I have my request to speak button on, but
Delegate Mugler.
sorry. So I'm a question for the patron.
Delegate Mugler.
Just trying to understand the intent of the bill. Is this for the, let's just say, for example, the yellow bus service? Or are you talking about transit?
It's for the yellow school bus service.
Okay.
For those school boards that already offer it. So if I've learned that not all school boards, school districts in Virginia may offer the yellow school bus. So if they don't, then they're not required to as a part of this bill.
Mr. Chair,
Delegate Rousseau.
I move to report the bill
There's a motion. Is there a
as
second?
substituted.
There's a motion and a second to report the substitute. Members will record their vote. Bill reports on a 6-0 vote. Thank you so much.
Great, thank you so much.
Delegate Willett.
Thank you, Mr. Chairman. This is regarding HB 376. And I have an amendment to that bill. Do you have that?
He's passing it out. Thank you, sir.
Mr. Chairman, those amendments are at Department of Education's request, basically to make the language here more consistent with other code provisions, so they're relatively straightforward on that end. And I think the bill itself is straightforward, but I want to make sure you understand the changes.
I would move the amendments.
There's a motion. Is there a second? There's a motion and a second to move the amendments. All those in favor express by saying aye. Those opposed? Delegate Willett.
Thank you, Mr. Chairman. I think everyone's aware that Virginia's K-12 schools are facing a very significant teacher and support staff shortage. I know this past year the school systems were more than 1,000 teachers short. This bill will require annual reporting to the Department of Education, first by school boards on the numbers and types of teacher and support staff vacancies. And then secondly, I would ask colleges to report on Virginia graduates who have graduated with education degrees. The idea is that this data would then help to document the shortage, but also to inform strategies to address the shortage, which, as I've said, is significant in the state.
Thank you. And this, if we act upon this legislation favorably, there is a letter for this to go to appropriations. Members, any questions? Anyone here to speak in support? Anyone here to speak in opposition can line up and or.
Chairman, members of the committee, Kathy Bircher with the Virginia Education Association. We support this legislation. Aside from, although it was this morning, it was just today, this morning, hours and hours and hours ago. In the first sub, we did hear that describing this as a teacher shortage is potentially not accurate, that instead we have a profession where there aren't folks who are willing to go into it for a variety of reasons. We also know that there's a national decline, substantial decline in folks even entering, or students who want to be teachers entering our teacher preparation programs. We think collecting this data and putting it all together in one place so we can see those trends is incredibly important, and we support the legislation.
Seeing none, no additional individuals here to speak in support and none to speak in opposition.
Mr. Chair, I move to report
House
Bill 3.
There's a motion and a second to report
and refer to
and refer
appropriations.
to appropriations. Thank you, Delegate. Members will record their votes. This bill reports and is referred to appropriations on a 5-1 vote. Thank you, sir.
Thank you, Mr. Chairman.
Which one of you want to go first? Delegate Goditis?
Thank you, Mr. Chairman, members of the subcommittee. So you already heard, Mr. Chairman, you already heard from David Reed, Delegate Reed, that we're kind of combining these bills, rolling his into this one, his 725 into this one, 1469. And the reason for that is my bill was it was broader. But I am here to add an amendment that that includes the category that he wanted included. I have copies of the amendment, and
Do you have that already? Could you explain that amendment?
yes, Mr.
Will
Chairman,
you
it
explain
adds
that
a
amendment?
line, I'll tell you where in a second, but it adds a line that says, or in a school for students with disabilities. So this is about increasing the time for a teacher to get a provisional license. And last year it was done for the public schools. My bill was covering private situations as well, private institutions as well, and Delegate Reed wanted to be absolutely sure that schools for students with disabilities was also included for teachers who wanted to get their provisional license.
Okay, hold on one. Is that a motion?
Mr.
There's a motion and a second to move the amendment.
Mr. Chair, I just want to make sure that we have the proper amendment before us. So your amendment is just the underlined portion, not the entirety of the text that is before us.
No, so, okay.
Give us one
I
moment.
guess
Give us one moment.
The reason why I say that is
Give us one moment.
Mr. Chair, I move the underlined portion of what was just handed to us as an amendment to House Bill 1469.
Thank you. Ryan, you want to provide some clarity?
Thank you, Mr. Chairman. So the underlined portion is that's the provision of Delegate Reed's bill. So it's really just incorporating that into Delegate Goditis' bill, and then they would be
Thank you.
rolled into one.
Is there a motion to incorporate House Bill 725 into House Bill 1469?
So moved.
There's a motion. Is there a second?
Second.
There's a motion and a second to incorporate. All those in favor express by saying aye.
Aye.
Those opposed? Chair would entertain a motion on 1469.
Move to report House Bill 1469 as amended.
Second.
There's a motion and a second. Members will record their vote. Report 6-0. Thank you, Delegate.
Thank you, Mr. Chairman, members of the subcommittee.
King. Yes, sir.
Mr. Chair, members, thank you very much for your time. House Bill 405. This is a bill that I first introduced about 2 years ago in this, what used to be the subcommittee. And at that time, it was the first time that the General Assembly had considered the issue about, especially young women in schools who are experiencing menstruation for the first time or just in the first years in their school, and how as at the time when they're going through a period, it has an impact on their ability to stay in the classroom because they're either trying to find nurses' offices if they didn't bring their pads or tampons. And so we learned that there was a disruption in the classroom, and it makes it hard for some girls to concentrate in their school studies. So we thought one idea might be to require schools to provide access to menstrual supplies to the students in a place that they can easily access it. So it was the first time we had this conversation 2 years ago, and after a lot of debates and discussions, the bill ended up not moving forward, although we did have bipartisan support. It was just that we weren't quite sure how to make this work. So as a compromise, the chairman at the time sent a letter to the school Department of Education through the superintendent asking all of our school divisions around the Commonwealth to try this out as pilot programs, see if this works, and give us some best practices. As a result of that, Mr. Chairman, 2 years later, we have a bill now here in the other chamber that would now try this again. And the good news is, in the last 2 years, we've seen many, many schools try this as pilot programs, including my own jurisdiction in Fairfax County. And the schools are now essentially telling us some of the practices have had, best practices as otherwise. And so we think that this is a good time for us to revisit this issue, to now require that all schools in Virginia, in those buildings where we have students from 5th grade to 12th grade, would be able to access these products at no cost at a time when they need this product. And that's really all the bill does. If you read through it, its bottom line is it's a bill that would require school boards to make these products available to students.
Delegate King,
Yes, sir.
this product is already provided through the guidance department of school nurses, or at least in where I come from. What is the difference here?
Mr. Chairman, I'd answer the delegate by saying that what we're requiring here is, number one, consistency and uniformity, because some schools, like the one that you've led and others, may have had a great program that already allowed it. But what we find in particular, we can hear from students who've gone through this, is that if you have products available either in the nurse's office or in the guidance office, but not available in a bathroom where a student happens to be in, then she would have to then look for that opportunity to go take more time out of her class to do that. The other thing that I've heard from many students, both at home and other places, is that some young students who have a period, it might happen suddenly in a classroom, and they may be with a male teacher, in which case it becomes kind of an awkward conversation for them to say, can I leave to go see a counselor or a nurse? And so we want to avoid that type of situation, to destigmatize the idea that girls obviously naturally have to go through periods. And so we want to be able to have this conversation in a way where they can just go straight to the bathroom during their breaks and take care of their needs without having to go through an adult. And so to the extent that supplies may be available in some schools, it may not be accessible to that student when they need that. So that's really what we're trying to do, is allow for that kind of access. And Mr. Chair, I believe we have a few students and others who have come to speak in favor of the bill at the appropriate time.
I'm sorry, Mr. Chair. I do have, I'm coming from working, on the local level. So I do have some concern about the fiscal impact to the localities. And I noticed on the fiscal impact statement that there's obviously no impact to the state, but then what's happening in the local division is indeterminate. So I'd have a concern about the fiscal impact and how we would deal with that. I hate to press more things down on the localities.
Mr. Chair, I'd answer, if it's okay, I'd answer Delegate Mugler by saying that it's no question there that this is a mandate, and there's no question that there may be some costs associated with the local schools. As I said, we tried this now for 2 years. We've asked local schools to be able to experiment, try different ways to do it. Some schools have been really innovative in finding nonprofit partners that donate the products on a regular basis. In fact, I've been involved with that program now myself personally, where we have a nonprofit that receives donations from throughout the community and or from corporations, and then they'll partner with the schools to buy the dispensers, install that, and make that available. That's one way that nonprofits and corporations are actually giving back to the community in a way that's meaningful to them. I've also seen schools where they just say, this is such a necessary product, just like any other medical devices or anything else they need to stock in their bathrooms or in their nurse offices, that they'll just absorb the cost. And again, we've also last year passed a bill that reduced the sales tax on tampons and pads and other menstrual products as a way to say that these are cost factors that the state ought to absorb for the purpose of public policy. So we're heading in the direction where we want the government to be responsible to the extent they can to make sure that our students are getting the education that they need.
Any individuals here to speak in support? Those individuals here to speak in opposition can line up behind.
Hi, I'm Clara Katropia. I'm a freshman at Douglas South Hall Freeman High School in the Henrico County Public School System. I think this would be really important as a female in freshman year in a high school. My high school does supply feminine hygiene products in the nurse, but it could be extremely effective if we supplied those in bathrooms. As he was saying, it is an extremely awkward conversation to have with a male teacher, and sometimes male teachers aren't supportive of needing to go to the nurse, and it can mess up if you possibly bleed through your pants. And also in more low-income areas, people even at home they don't have access to feminine hygiene products. And I know peers who have had to stay at home through their menstruation cycle, and they miss out on school because they don't have access and they don't want to free bleed through their pants in school. That can be an extremely embarrassing situation. So I think this bill being passed can help with people attending school more and people concentrating more and not having to concentrate on something that they don't have products for in the education. Thank you.
So I'm Chris Katropia, actually the proud father of Clara Katropia. I'm also a professor at the University of Richmond. And hearing some of her stuff, I've actually studied this. And it looks like, at least some of the studies that I've done empirically, 3 times more likely to miss school if products are not available in the bathroom, 2 times more likely to leave school early if products are not available in the bathroom. And I'll just say from experience, even in Henrico County, there are schools in Henrico County that don't even have products in the nurses' station. And so I think that this legislation is really important important to kind of wedge this loose and allow us to give these girls access to something where I actually had access to something called toilet paper. I didn't need to ask for it, right? I could actually go get it out of the bathroom. So I think that this needs to be done in Virginia like it's been done in some other states already. Thank you very much. I support this legislation.
Thank you. You can continue.
Okay.
I think there was,
All right, good evening.
in 4 or, like, speaking in.
Four, yes.
Yeah, so just state your name. And
Okay. Amanda Lloyd. I'm the president of the Junior League of Norfolk, Virginia Beach, and I'm proud that our organization is at the forefront of making great strides in the Hampton Roads community regarding the issue of period poverty. Menstrual products are not a luxury.
That's all we can do.
Thank you so much.
Will Shaw, Louisa County, father of 3 daughters. This bill's a no-brainer, gentlemen.
Which way, no brainer? Good or bad? Just want to make sure.
Mr. Chair, members of the committee, Bev Lammy, Henrico Schools, and I apologize to Delegate Keem, just bringing a comment about the bill that I just got a call from our school nursing supervisor. Absolutely supportive of the concept of the bill. She would support the pads. She does have medical issues about students. There have been cases of students too young that have been using tampons. They don't understand the clinical recommendations about how often they're changed. So she would ask that you consider just pads for all the students. Thank you.
Mr. Chairman, Stacey Haney with the School Boards Association. I just want to raise a concern, and this is more broad and probably, well, this is a more broad concern, and that is that we are passing, or this subcommittee, the General Assembly is passing a lot of mandates this session. And I can't take issue with this, and I commend the young lady who spoke in support of the bill. And I would just ask that you all take a big picture look at all the mandates that are being imposed. I mean, this does have a local cost, and it's great that have been pilot programs and nonprofits, but I'm concerned that there are some of our more rural localities are less able counties that this is going to impose a local cost. And so just think about that and think about in the bigger picture of all the mandates that we're passing. I understand this is an important one. I understand that it's well-intentioned, and I can't take issue with it. It's just the local cost that we ask that you be aware of as you consider this and all of the other mandates that you're considering this session.
What did you think about the consideration of that suggested amendment?
Mr. Chair, I'd answer by saying that is certainly a legitimate point to raise, but if you read the bill, and we've had this conversation with some of the other folks as well, if you read the bill, there are 2 sections where that would come up. One is in the definition of menstrual supplies. It means tampons and pads for use and so on. So in the definition, you want to be as broad as possible so that you can say these are the products, so that we have that. And then on the actual bill itself, it says it shall make menstrual supplies available at all times at no cost. The way I would interpret this, and I've had this conversation with my own county, is the counties, as the local governments, can decide what type of dispenser and where specifically in the building that's most accessible for them, at their most costly. If a county says, in our county, we only have dispensers that have one product, not the other product, they're meeting the intent of this. They're meeting the spirit of this. So I don't think that we need to be fine-tuning the language here. We leave that part up to the local governments to decide.
I'm asking council if we need to put and or.
Mr. Chairman, so I would recommend either just and or just or. If you keep and, that would mean that they would have to have both in the schools.
Okay.
If you change it to or, they would have a choice to do tampons or pads or both. So
Mr. Chair, just to clarify, are we talking about line 14?
Yes.
Yes.
Mr. Chair, I would be okay with that because I think the concept here is we want to define it in a way where we're addressing the products. We don't want somebody to say, what is a menstrual product? We want to be able to talk about what it is by using examples. And so whether it's an and or, legally it doesn't make much of a difference because all we're saying is these are the types of products. So
Well,
I would consider that to be a meaningful change.
nobody's made it yet, though.
Mr. Chair,
Delegate.
I have another suggestion. I would, and I wanted to get your opinion, if we struck tampons and pads and inserted something along the lines of supplies for use in connection with the menstrual cycle, that way it leaves it nice and wide open and we don't have to pick one or the other. So, Mr. Chair, I would offer that as an amendment, since I don't hear an objection.
Mr. Chair, I was just thinking about that. And this might be for council. Mr. Burma might be able to tell us, but wouldn't that be a definition that defines itself? I mean, literally, when you say menstrual supplies means supplies used for menstruation. I wonder if there's any legal meaning behind that, because if you're not singling out, it's like having a code section that refers to another code section to define something. You're just basically repeating the same concept. So I get where you're coming from, Delegate Rasool, but I think just from a legal perspective, I don't know if it does what we want to do. So I understand the intent, and I wanted to help you get to the same goal.
No, we want to help you.
I think the OR does a little bit better job on that, Delegate Rasool, only because when you say supplies for, then you're basically saying, you're redefining what you just said the definition is.
Mr. Chair,
Delegate Rasool.
I would move to strike and insert or as an amendment.
There's a motion and a second to strike or and insert or. All those in favor express by saying aye.
Aye.
Those opposed? Any additional? Delegate Mugler.
Thank you, Mr. Chair.
Delegate Mugler.
You mentioned that there had been some pilots done with this. So when they did that, how did they dispense and control the product?
Mr. Chair, if somebody in the audience wants to answer, because some of the school divisions may have already done it, they can answer you directly. My understanding, based on the reports I've had, is so far there have been very good positive examples where, I know in Fairfax County, for example, and Prince William, I believe, is the other county, where they came in, different nonprofit groups came in as a partner. They chose dispensers in the marketplace. They decided where would be the most appropriate locations within the buildings. Obviously, the bathrooms are the best place. And then they would stock it on a regular basis. And whoever uses it, I mean, one of the big concerns that was raised early on was, what if somebody comes in, just steals a whole bunch and tries to hoard it? But turns out, based on experience, that just does not happen. This is not a kind of product that people go in just to manipulate or just to play around with it, just steal everything. I think people respect each other enough to know that this is used for a good purpose. And so far, I have not heard any negative situations that's been played out in the pilot.
Is there any additional questions from members?
Mr. Chairman, not a question, but just a comment. I'd feel a whole lot better if there were language in here saying the state was going to bear the cost of this initiative. I feel a little absurd being the only woman on this panel that has an issue with this bill, but the bill is very well intended, and I totally embrace the idea. I just am concerned about pushing the cost down to the localities, which they already cannot bear more cost.
Mr. Chair?
Delegate Rasool.
Mr. Chair, just wanted to advise the subcommittee, I did put in a budget amendment just in case, because I hadn't seen the fiscal impact when I drafted the bill. So I did put in a budget request, and of course, we all know how budget requests work. So to the extent that there would be any state costs, and Mr. Chair, I would agree with Delegate Mugler that in the ideal world, the state should be paying for everything that we do in public education, including teacher salary that's up to the national level. That would be the ideal world. We're not living in this world right now.
All right, members. Second. There's a motion and a second. Members will report their vote.
very robust committee.
On a 3-2 vote. Thank you.
Thank you, Mr. Chair.
No, she left an extra from that. Delegate Delaney.
Thank you, Mr. Chairman, members of the committee. I've got a substitute for HB 415.
Is there a motion?
So moved.
There's a motion to report the substitute. Is there a second? There's a motion and a second to report the substitute. All those in favor express by saying aye. Aye. Those opposed? Delegate Delaney.
Thank you, Mr. Chairman, members of the committee. The bill before you requires school boards to adopt policies and procedures to ensure that suspended students are able to access and complete graded work that they missed during their suspension. Currently, some school systems bar their students from receiving graded work while on suspension. Not receiving graded work during this time unjustly penalizes the child, strips them of their right to an education, sets them up for academic failure, and potentially adds years to their academic experience, and has a risk to add them to the school-to-prison pipeline. So the bill before you is simple. It asks that the school boards adopt policies and procedures to provide students access to graded work. This policy will ensure that our students are still connected with the curriculum and able to return to their school without being days or weeks behind their colleagues.
Delegate Van Valkenburg.
Thank you, Mr. Chairman. Mr. Chairman, Delegate Delaney, there's really school systems that refuse to give work to students who are suspended?
Mr. Chairman, I would say yes. Unfortunately, there was a parent who I know was hoping to be here today, but I received word that she was not going to be able to join us with her testimony. But we have heard that that this, while maybe isn't happening in my district in Fairfax County, and perhaps in others, but Hampton Roads area has reported this as well as Newport News, and I'm sure that this is a practice that is happening elsewhere.
Any individuals here? Any individuals here to speak in support? Those who are here to speak in opposition can line up behind them.
Mr. Chairman, members of the committee, Kathy Bircher with the Virginia Education Association. Much like Delegate Van Valkenburg, we were surprised to hear that this was indeed the case with some school divisions. We support the legislation.
Mr. Chair, committee members, Amy Woolard with Legal Aid Justice Center. I can tell you from having many clients in this circumstance, it definitely happens, and it happens throughout the state. I think that the problem is slightly larger than this when it comes to suspending kids and not having them be able to participate in the curriculum and get the education to stay on track. But this is certainly one piece of a way to address that. So we do support the bill.
Mr. Chairman, members of the subcommittee, Bette Neal with middle and high school principals. My board does support this practice and policy. Thank you.
Thank you. Members, what's your pleasure? To report. There's a motion in the second to report. As amended.
Move to report as amended.
There's a motion and a second to report as amended. All right, members, report the vote. Reports 3-2.
Thank you, Mr. Chairman. Thank you, members of the committee.
Delegate Creasy.
Thank you, Mr. Chairman. My bill, HB 501, came at the request of Fairfax County Schools and the Fairfax County School Board. I just got to tell you, I mean, it's all we're doing. This is a great committee to be in because it's education, and this is all about writing and how important even the word "and" is. So we're striking the word "and" on line 77 so that it makes it clear what the intent of that code section really is, and what it will, by striking "and," it will permit the school boards to designate another entity or individual to participate on their behalf in the annual review of a written school crisis, emergency management, and medical emergency response plan. And that was the bill that we passed last year, which added a number of participants to the required annual reviews of written school safety plans. But by having the word "and" in there, and it has a comma afterwards, which is even more incorrect, right? I see the teacher in the crowd here, right? So it's so this is poor grammar, and just this poor punctuation error, and it just cleans up. This removes a mandate, frankly, that all the school board has to show up. So I've got folks here from all the school board members I would imagine would want to support this, but the county's here, and I think that's it. Just let's get rid of the word "and."
Anyone here to speak in opposition? Anyone here to speak in opposition? Members? There's a motion. Is there a second?
Second. I'll speak against it if you need something. Maybe we should vote against it just to make it more.
There's a motion and a second. Members will record their vote. Bill reports 5-0.
Thank you, committee. Thank you, Mr. Chairman.
Delegate Mullen.
Thank you, Mr. Chair. I appreciate the accommodation since I think we will probably be in crim law sub a little bit longer than most. I have HB 257, I believe. Council, do we have any line amendments at this point? Or is it a substitute? I apologize. It is an amendment in the nature of the substitute.
Thank you.
HB 257 goes through and says that there are going to be less things that we need to mandatorily report to law enforcement, giving more discretion to principals, school boards, teachers to be able to evaluate the nature of student behavior. What we've found over the course of the last decade is that we've been continuing to criminalize conduct that at one time meant that you and I would be sent to the principal's office. Now, because of regular access to law enforcement, there are some people who have been referring kids for kicking a trash can. I had one of that when I was prosecuting. Yelling and tossing over a desk. All things that are totally inappropriate and disruptive to the school environment and need to be properly punished, but didn't need to go through my courtroom as a prosecutor. There are gradations of behavior that children have, especially when they're in need of guidance or perhaps they have mental health, emotional, family situations that could be creating some problems. So what this bill does is first, and perhaps for practitioners alone, it cleans up this section a tremendous amount. So on a functional level, this was a really difficult code section to be able to parse and read, and so we were asking administrators and principals to be able to read something that even I as a lawyer had some tough time with. And then it says, if it's a felony, if it's sexual battery, stalking, parental abduction, oral threats to kill a school employee, threats to bomb a person, all the sorts of the really bad, scary things that you still need to call law enforcement. But if two kids get into fight over a girl, that you don't have to call police unless you think you should. In which case you always can. There's never a prevention saying you cannot call law enforcement to be able to intervene. It does a number of other similarly situated situations, but if school administrators, school principals, school teachers think they can handle it, then they should. So that's what this bill is. I'm happy to answer any questions. I know that there's some people who would like to be able to speak on the bill as well.
Yeah, and I certainly understand, over the years, it seems like they've been criminalizing normal well, not normal, but bad, what should just be considered discipline problems rather than criminal problems. I mean, even if this gets reported, something gets reported to an SRO and a Commonwealth's attorney, they still have prosecutorial discretion, don't they? They don't necessarily need to prosecute it, do they?
And you know what? I would say that as someone who's handled those cases for a very long time, you're right. And most of the time I would issue discretion, but by that point they had to go get a lawyer. They had to leave school for 3 or 4 days. They had to go through the court intake process. They had to possibly go through a deferral process that's pre-adjudication, like I'm sure what you would be anticipating in those things. And that's an expensive, difficult, and sometimes laborious process. I'll give you an example of a student that I had. This was a student who was clearly disruptive in the classroom, needed to be out. And while they did that, they kicked a trash can. As a result, they were charged with destruction of property. Now, this is ridiculous. I mean, no one was hurt. Nobody was in the line of the trash can. They kicked a trash can. It's one of those aluminum ones that we got sitting around all over here. That young man, who was 15 at the time, he was brought in and put on a deferred disposition in my court. And so he was put on juvenile probation for a period of 6 months. The conditions of juvenile probation are always that you regularly attend school. Now, the problem is if you're in a kind of a kid who's in a situation where you're kicking trash cans and making noise, it probably means that there's some other things going on in your life that are difficult to be able to deal with. And maybe not attending school is one of the symptoms of that problem. And so that young man was placed on juvenile probation and failed juvenile probation because he wasn't going to school often enough because his mother was working 2 jobs. And she wasn't there to supervise him in the way that hopefully all of us as parents would be able to do if we were so blessed. This means we don't have to do that unless the administrators really think it's appropriate. But yes, there is always going to be discretion from law enforcement. There's going to be discretion by the court. There's going to be discretion by the Commonwealth's attorneys. So hopefully we don't find ourselves in situations the likes of which I'm describing. But that's still a difficult and onerous process on a 15-year-old.
Thank you.
Any individuals here to speak in support?
Mr. Chairman, committee members, Amy Willard with Legal Aid Justice Center. We are in support of this. We've tried measures like this in the past. I think over the years, what I've heard in response to the notion that Virginia sort of leads the way in sending students to law enforcement is this mandatory reporting statute standing in the way. So I am looking forward to making much of this more discretionary, and in turn, hope those refrains become look at our numbers decreasing of kids who are going to law enforcement. So I see this as kind of a litmus test against what I'm hearing from schools, which is that they want to send fewer kids to law enforcement. I would love for you all to give them the tools to do that, and then I will happily be watching how that unfolds. So we support the bill.
Good afternoon, Mr. Chairman.
In support or?
Support. Delegates, and some people seem surprised, but the Virginia Association of Commonwealth Attorneys, and I'm John Mahoney, that's who I represent here today, are in favor of putting school discipline back in the schools. And I'll tell you that when I ran for office, my first meeting was with the school superintendent to do just that, and we've greatly reduced cases from the schools. So we think this is a good thing. We like the discretion in it. But I will raise one concern on line 25. We're just talking about drugs, not marijuana, but other drugs. And my concern is that those drugs aren't properly identified. Who knows if an imitation-controlled substance really is an imitation? That typically would take a lab to tell us. But generally, great bill. Thank you.
Mr. Chairman, Stacey Haney on behalf of the School Board Association. We also support the legislation. One of the things that Delegate Mullen said in response to Delegate Cole's question about prosecutorial discretion was the prosecutor has discretion, the courts have discretion, the judge has discretion, the SRO has discretion. Under the current law, the only person who doesn't have discretion is the school principal, and this bill would give the school principal a measure of discretion for some offenses to not involve law enforcement. We would urge that you support giving our administrators that discretion.
Mr. Chairman, members of the subcommittee, Bette Neal with middle and high school principals. We do support the bill for the reasons previously stated. Thank you.
Mr. Chairman, members of the committee, Kathy Bircher with the Virginia Education Association, we are incredibly proud to stand with our good friends at Legal Aid Justice Center to support this legislation.
Thank you. Members, do I have a motion to incorporate House Bill 695 into House Bill 257? So there's a motion and a second. All those in favor express by saying aye. Aye. What's the will of the body of the committee on House Bill 257? Move to report. There's a motion. There's a second. All those in favor? Oh, excuse me. Members will record their vote. The substitute reports on a 5-0 vote.
Thank you, Mr. Chairman.
I'm on my way to your committee.
We'll look favorably, I promise.
Be there in about 20 minutes. Let me do this. The Delegate Lopez. No. Let me do this. Delegate Lopez and Delegate Guzman have a bill that needs to be incorporated. Delegate, come on up, Delegate Guzman. And which bill are you wishing to incorporate? I believe that is incorporating House Bill
897.
897 into 1135.
I think it's going to be incorporated into Skylar's bill.
Yeah, into 292. Emily, you already did 897, 1135.
Say that one more time.
1135 and 896.
We already talked about that.
Okay. Yeah, I'm sorry. So 895, 1135, and 292.
You want me to do my bill? Is the will to incorporate Lopez's bill? This is on the first page.
You want to go talk to Lopez about that?
Why would you?
Both of y'all have the same bill.
He's going to incorporate it into mine.
You already talked to him?
Yeah.
Okay. So is there a motion to incorporate with Lopez's approval, incorporating House Bill 1135 into 292? There's a motion.
Second.
Is there a second?
Second. What was that?
All those in favor express by saying aye. Those opposed? Thank you. And with that,
I have one more bill.
you have one more bill.
Yes.
Okay. Hers will be really easy.
Okay, Mr. Chairman. Why it has to be so difficult? House Bill 570.
Delegate Guzman.
Thank you, Mr. Chairman. I would like to present to you an amendment in the nature of a substitute.
Is there a motion to move the substitute?
Second.
There's a motion and a second. All those in favor express by saying aye. Those opposed? Delegate Guzman.
Thank you, Mr. Chairman. This bill is about repealing from the code lines 21 through 23, and I'm going to make it very simple. In Virginia, Virginia and another state are the only ones who could dismiss a teacher by not having a one performance evaluation to be satisfactory, and we wanted to repeal that part of the code. We believe that teachers deserve, like any other public employees, opportunities for improvement and opportunities to improve their performance. The current definition reinforces the punitive nature of our system of evaluating teachers, just as the Commonwealth is striving to build an evaluation model that is designed to improve instruction and lift student outcomes. Also, the current definition includes language that is unnecessary and confusing, and the current code further defines incompetence as the consistent failure to meet the endorsement requirements for the position. The bill does not strive to change the reasons for which a teacher can be fired. It simply removes the current definition of incompetence, since it's overly prescriptive and at the same time includes language that is unnecessary. Teachers can still be fired for all the reasons listed, including competence. And that's what the bill does, Mr. Chairman. I think it's an opportunity now that we are making public education a priority of the Commonwealth. We should also treat our teachers fairly and give them more opportunities to succeed and stay in the Commonwealth. And I hope if that is the pleasure of this committee and yours to pass this bill.
Mr. Chairman, members of the committee, I'm Kathy Birch with the Virginia Education Association. This, along with the other bill that we had earlier, are some top priorities for the Virginia Education Association. Delegate Guzman expressed it really eloquently. The intention originally when we looked at this section of code was to remove one evaluation as a part of a definition of incompetence, particularly as Virginia is moving away from the punitive nature of teacher evaluations and ensuring that teachers are receiving the professional development and support they need to be effective, rather than being after one unsatisfactory evaluation being claimed to be incompetent. And in fact, the code also says you shall not be rehired. And so while we were looking at that section and removing the one evaluation, worked with some other stakeholders and recognized that what was left in that definition actually does not apply to the definition of incompetence, because a school division can't hire someone if they aren't licensed to teach the content. And so the place we landed was to remove that definition. It does not change incompetence. It actually allows school divisions the authority to establish what incompetence looks like for them, and we are hopeful that you can support the bill.
Mr. Chairman, members of the subcommittee, Beth Neal with middle and high school principals, we did not have a concern with the original language because we do support more than one evaluation to dismiss a teacher. We are concerned with removing the definition of incompetency, and wanted to make that point. Thank you.
What's the will of the committee?
Move to report.
There's a motion. There's a motion and a second to report House Bill 570. Members will record their vote on House Bill 570. Report the substitute.
Report the substitute.
Motion and a second to report the substitute on 570. The substitute reports 4-2. Thank you, Delegate.
Thank you,
Guzman.
Mr. Chairman. Members of the committee.
A couple things we need to do. First is there a motion to incorporate House Bill 1469 into House Bill 725? Hold.
We already did 725 into 1469, and I guess we need to do 1326 into 1469 as well.
Okay.
They decided to do 725 into 1469.
I think 1326 should probably go in 365. Just in terms of subject matter. Should probably also go into this one. If you're looking for one to incorporate.
All right, I'm sorry, members. Is there a motion to incorporate House Bill 1326 into House Bill 365? Is there a second? Is there a second? Anywhere? There's a motion and a second. All those in favor express by saying aye. Those opposed? Thank you. Next, is there a motion by request of the patron to carry over until 2021 session, House Bill 109, patron by Josh Cole? There's a motion. Is there a second?
Second.
All those in favor express by saying aye. Those opposed? Thank you. Next, we have Delegate Lopez. Lopez.
Thank you, Mr. Chairman, members of the committee. I have an amendment in the nature of a substitute.
Where can we find the substitute?
Okie dokie. I have it right here. It's the language is HB 860. Or it's right here, actually. Can I give it to you?
Which bill are you?
I'm talking HB 1174. It's regarding the use. It's asthma and the use of albuterol in schools.
1174.
1174.
Give us one moment.
No. It'll come.
Is there a motion to accept the substitute? Ryan, would you explain the substitute?
Mr. Chairman, the substitute would make this bill identical to House Bill 860, which was a bill carried by Delegate Bell related to asthma medication and professional use by practitioners, which that bill already made its way through the HWI committee.
Is there a motion? All right. Members still reviewing.
So moved.
There's a motion and a
Second.
second. There's a second. All those in favor express by saying aye. Aye. Those opposed? Delegate Lopez.
Thank you, Mr. Chairman. According to the CDC, across the United States, more than 6.1 million children suffer from asthma, which is the leading chronic disease among the pediatric population. As of 2016, more than 129,000 Virginia children live with asthma. Among children aged 5 to 17, asthma is one of, if not the top causes of missed school days, seat time, and therefore instructional time. Uncontrolled asthma also disproportionately affects lower income and populations of color. Because asthma triggers can include poor air quality, mold, and a host of other factors, it is not surprising that asthma is a leading health equity indicator. HB 1174 takes a positive step towards addressing this problem for so many of our kids by allowing local school boards to adopt and implement policies for the possession and administration of undesignated stock albuterol inhalers in schools. School nurses, employees of the school board, employees of a local governing body, or employees of a local health department who are trained in the administration of these inhalers would be allowed to administer the albuterol inhalers for any student believed in good faith to be in need of such medication. The bill also limits the liability of any such individuals who provides, administers, or assists in the administration of albuterol inhaler for a student believed in good faith to be in need of this medication and the prescriber of such medication. If your child has asthma, has a prescription for an inhaler, and attends school, this bill changes nothing. The intent of this bill is to ensure that there is access for children who either do not have an inhaler, cannot afford an inhaler, or for whatever reason have lost their inhaler. Anyone who has experienced asthma knows the only thing worse than dealing with it themselves is watching a child struggle to breathe during an attack. The seconds it hopefully takes to get to the rescue inhaler can feel like hours. And my hope is that by passing HB 1174, we can help alleviate the suffering of children suffering from this condition. And additionally, with the other steps I know the Commonwealth has taken over the years, control this chronic condition and keep kids safe in their seats at school. I hope it's the will of the committee to pass this legislation, Mr. Chairman.
Thank you. Any individuals here to speak in support? Anyone here to speak in opposition? Members?
Move to report.
I'm going to come up and say we support it. We thank the delegate for putting this in, Carter Beatty with Children's National, but I'm not going to get anywhere. I liked that motion.
Will Shaw, Louisa County. It's a great bill. I was an asthmatic child. We didn't have albuterol back then. Hope you vote for this bill.
There's a motion. Is there a second? Second. There's a motion and a second. Members will record their vote. The substitute reports 5-0.
Thank you, Mr. Chairman.
Delegate Weaver.
Thank you, Mr. Chairman. Committee.
All yours, Delegate.
I bring House Bill 939. Thank you, Mr. Chairman. What House Bill 939 does is it requires local school boards to provide firearm safety education program to high school students. The Board of Education will work with Virginia State Police to establish curriculum guidelines. The class will be taught by a resource school officer or other law enforcement officer. It shall provide a curriculum guidelines that shall incorporate other principles like Eddie Eagle, etc. And no firearms shall be used in the firearm safety education program. The primary reason that I brought this bill forward, although judging by the series of mandates that I saw before that did not move forward, the reason being is there's always a stigma when it comes to firearms. And it's not necessarily a bad thing that firearms are, it's one of those things where, so for instance, with my children and the way I grew up, a familiarity and an understanding of what they can do, an understanding of how they function, can benefit in that you have a healthy respect for them. As well as if a child, if a high schooler or somebody that is not used to them has some knowledge on how they work and what they do, they are therefore more prepared to deal with them if they are found else, in a park or anything like that. As well as one of the interesting things about firearms is the fastest growing sport tends to be clay shooting in our high schools, in our colleges. And so by providing safety education, et cetera, with firearms, we are also creating a base for which that student can then move forward. But again, judging from the numerous mandates that have been put forward, we'll see what the will of the body shall be. And I see Skylar smiling, so.
Any individuals here to speak in support? Anyone here to speak in opposition?
Mr. Chairman, Stacey Haney with School Board Association. We have some concerns with the legislation. We believe it's a mandate. Current law permits school boards, or I mean, it is a mandate. Current law permits school boards to offer this if they choose to do so. and the department has developed the curriculum is available. So currently, it's an option. The other thing that I think is really concerning about the legislation is that it requires that it be embedded in, it changes it to be embedded in the family life education curriculum. And I think that's a real problem. You know, currently we let families decide whether they want to opt out of family life education. And I think embedding firearm safety into the family life education is going to cause a real conundrum for some people who might want their child to receive the family life education curriculum, but maybe they don't want their child to receive this curriculum, and they're going to be faced with making that choice. And so for both of those reasons, we would ask that you not advance legislation.
I didn't move fast enough. I'm in support of the bill, Wilshaw, Louisa County. I think this is a good bill. It's the safety of the children we're talking about. It's appropriate that it be in the family life program because that ensures that it is age appropriate, and it's talking about 2 hours. Anybody that's naive, it would be naive to think that, you know, any particular kid is not going to ever encounter a firearm because that particular home doesn't have firearms. The kids play at other people's houses. They go to the park. They go to the restroom in the school. It's a good possibility they're going to encounter a firearm, and we want children to understand what to do and what not to do. And I think it's a good bill, and I hope you report it. Thank you.
Mr. Chairman, Tom Smith, Superintendent's Association. For the reasons stated about Ms. Haney, we're opposed. We've got to remember that it seems every year we're coming down and loading more things into family life education. And so we would like for this bill not to progress. Thank you.
Mr. Chairman, members of the committee, Kathy Birch with the Virginia Education Association. We'll associate ourselves with the comments from Ms. Haney and School Boards Association, and we oppose the legislation.
Bette Neal with middle and high school principals. We oppose for the same reasons. Thank you.
Mr. Chairman, I certainly appreciate their brevity. If I will say the reason that it was embedded in the family life education is simply to provide that opt-out so the parents could, if they wanted to, not to. But that's it. I appreciate the gentleness of the table. Thank you all.
Yes, sir, Mr. Chairman. Where you left off is that there was a substitute adopted that would essentially incorporate the provisions of the bill as a Section 1 bill instead of amending the code.
Mr. Chair, I believe that I had made that amendment to the bill. I think it's in proper posture, and if it pleases the chair, I would move that we report the bill as amended.
There's a motion. I don't know anything about what happened on the floor here.
Mr. Chairman, can I ask a question of council? Can council just explain exactly what the changes were, since I wasn't here when these changes were made?
Sir, Mr. Chairman, Delegate Van Valkenburg. So it would essentially, substantively be the same bill, but it would be a Section 1 bill instead of amending the code. So it would still have DOE coming up with guidelines related to excused absences for mental and behavioral health, and then the school divisions using those guidelines to grant those for students.
There's a motion. Is there a second?
Second.
There's a motion and a second.
Mr. Chairman, why don't we start with 1443? All right, thank you, Mr. Chairman. 1443 requires the Department of Education to conduct an annual review, review of teacher compensation that takes into consideration the Commonwealth's compensation for teachers relative to member states in the SREB. The Department of Human Resource Management was tasked with conducting a biennial review, and this was a mandate for which the DHRM had no authority or oversight, and so this just kind of changes who does it. It aligns the reporting responsibility with the superintendent of public instruction, who already has access to this data, and so I hope it is the will of the body to move this bill on. And Mr. Chairman, I should say this is just a bill to amend and reenact the part of the code that is related to the submission of this report.
Any questions from members? Anyone here to speak in support? Anyone here to speak in opposition? What's the pleasure of the committee?
Move to report.
Second.
Motion, is there a second? There's a motion and a second. Members will report their vote. House Bill 1443 reports on a 4-2 vote. Delegate Van Valkenburg.
Thank you, Mr. Chairman. Mr. Chairman, let's take up next House Bill 292. And if it would be the will of the body, I would like to strike two words that are on line 23. This would kind of clarify the legislation and put it in the same posture as the Senate. And those words would be at the end of line 23, strike the words "and discussion." So it would just say opportunity for public input during each memorandum of understanding review period. So I would ask to move that amendment of striking those two words.
Is there a motion?
Second.
There's a motion and a second to accept the amendment. Delegate Van Valkenburg.
Thank you, Mr. Chairman. To give context, this is one of two bills that kind of come out of the Select Committee on School Safety and kind of touches on some of the issues we've been talking about this entire afternoon about the relationship between school resource officers and school administration figures. One of the things that we really talked about on that Select Committee was making sure that we are clarifying the relationship between law enforcement and schools so that law enforcement was doing law enforcement and school administration was doing school discipline. And really what we're doing here in this bill is we're making it so that the memorandums are every 2 years, and we're creating a public process for this. And the reason we want to do this is really we have a constant changing world. Two examples of that are the iPhone that some of you are holding in your hands this moment, right? And vaping, two things that popped up kind of overnight, and the relationship between what law enforcement should be doing and what the schools should be doing is unclear and vague. And so these MOUs help clarify that. They help law enforcement focus on the things that they should be focusing on, which is school safety, and they let school administrators focus on the things that they should be focusing on, which is school discipline. And so I hope it would be the will of the body to move this bill forward.
Yes, Mr. Chairman, committee members, Amy Willard with Legal Aid Justice Center. I mean, the bill does three simple things, as Delegate von Valkenburg has said. I think part of the concern in making sure that we are making MOUs useful and usable documents and not just sort of the dusty document on the shelf that nobody really knows what's in it because it can't actually function if people aren't engaging with it and if communities don't know what's in them and have some say in what's going on in those relationships. Schools look at their codes of conduct, I think, in large degree every year. I think this should go hand in hand in developing these kinds of documents as more community school law enforcement relationships as opposed to just school and law enforcement. And this enables communities to really participate in the process in a meaningful way. Hope you support the bill.
Mr. Chairman, members of the committee, Kathy Bircher with the Virginia Education Association, and we support the bill.
Good evening, members. My name is Catrice Nolan, parent in Loudoun County Public Schools with 3 children who are attending the school system. As a parent, just this past year, we understood, because of our review of Fairfax County Public Schools, that they went to a public process in reviewing their MOUs. I, as a parent, when reaching out to Loudoun County Public Schools, was told that that information was not accessible to us as a public for input. I then asked for a copy of it, was told that it was not available. I then submitted a FOIA request for that same MOU, was not responded to. Then submitted a FOIA request to our local sheriff's department. They then actually shared the MOU for us to review. So it was a rather cumbersome process for us to access that document. So I am in support of this particular bill because it does make it accessible to us as parents for us to provide public input. Thank you.
Mr. Chairman, Stacey Haney with the School Board Association. I just want to say that we appreciate Delegate Van Valkenburg making the amendment that addressed one of the concerns that we raised, and so that did resolve the concern we had. Thanks.
Move to report House Bill 292
There's a motion
as amended.
There's a motion and a second to report as amended. We will now record our votes. House Bill 292 report as amended. 292 reports as amended, 5-1.
All right, thank you, Mr. Chairman. Third of 4, let's do House Bill 271. This is the second bill that kind of is in line with the school safety project that we were talking about and some of the things coming out of the relationship between school resource officers and school administration. And so House Bill 271, actually, before I go any further, Ryan can report line amendments to this bill.
Thank you, Mr. Chairman and Delegate Van Valkenburg. First, on line 5, after school resource officers, strike and school security officers. On line 32, after school resource officers, strike and school security officers. On line 57, after school resource officers, strike and school security officers. Same change on line 62, after school resource officer, strike school security officer. And then on line 63, after identities of students, strike the semicolon, insert an and. And then on line 65, after available, strike the remainder of that line through school hours on line 66.
All right, thank you, Council.
Van Valkenburg.
Mr. Chairman, what that's trying to do is just create some clarity. School resource officers are employed by the law enforcement. School security officers are employed by the schools. So that's why we struck that piece. And then the last piece, we're just trying to get some clarity here. So the idea of this bill is we need information to help push these MOUs, to help understand what law enforcement are doing in our schools, to make sure that they're able to do their job. And I would just say from my end as a school teacher, and what you kind of see in schools is you often see, and I don't mean this, the school administrators are doing this because they're slacking on their job, but often you'll see that kind of relationship between school resource officers and school administration kind of blur. And so this is it's an accountability measure for both the school resource officer, but also for the school administration to ensure that when we're making these MOUs and when we're making policy, we have the data behind it to know what the right decisions are. And so that's what this bill is for. I'll gladly take questions if there are any.
Any individuals here to speak in support? Any individuals here to speak in opposition can line up behind her.
Mr. Chair, committee members, Amy Willard, Legal Aid Justice Center. It's as Delegate Van Valkenburg describes, we're putting more and more millions of dollars into school resource officers and more school resource officers into our schools. And we know from the discipline data that we collect, we are told a story about what's happening inside our schools, especially with regard to demographic data and geographic data. when students are getting suspended and disciplined in various ways that push them out of the school building. If we're going to be putting law enforcement in our schools, I think we need to know what's going on in there. I think communities have the right to know what's going on inside our schools. You know, here in Virginia, even we have had some terrible headlines about school resource officers using tasers and pepper spray and other types of implements on even middle school students. And I think right now there's just not really transparency about how they're functioning in our schools. And before we continue to invest more and more in law enforcement inside our buildings, we kind of need to know what's happening inside those buildings, what they're doing in there, to be able to justify this kind of state investment and local investment and having them there. So we hope you support the bill.
Mr. Chairman, Stacey Haney, School Board Association. As with the last bill, I just want to thank the patron and Ms. Woolard for taking our concerns into consideration and making some amendments. And I think with the amendments, it's a good reporting bill that'll provide important data not only to the public but to school boards as they move forward with looking at their MOUs in the review period.
Mr. Chairman, members of the committee, Kathy Bircher with the Virginia Education Association. We believe particularly in this lane of work, along with many other lanes of work, particularly here, the more data that we have, the better we can decision around what is effectively working for our students in our schools. And so we support this bill.
Thank you. What's your pleasure?
Move to report.
There's a motion and a
71.
second. Members, record your vote. As amended. There's a motion, House Bill 271 reports as amended, 5-1. Delegate Van Valkenburg.
Last but not least, House Bill 273. This is a bill about planning time for elementary, middle, and high school teachers. As the bill reads, elementary school teachers would receive an additional 15 minutes of planning period time, and we would make sure that there's at least 45 minutes of planning that is unencumbered, meaning uninterrupted in a given week. And kind of the background to this bill is that a lot of teachers have planning period until they don't, when they're pulled away for coverage, or they're pulled away for administrative meetings, or they're pulled away for something, bus duty. And we talk a lot in here about teacher retention, and we talk a lot about here in terms of teacher recruitment. And I've been beating the drum for the last couple of years that yes, pay is a major part of that, but so is the work environment. And one of the number one ways you can make the work environment better in a school for teachers is to ensure that they have adequate time to plan and to make sure that the next day, the next week, the next month, they feel prepared. And so that's what this bill does. This one, I assume, will have opposition. I can speak to it after they do, but yeah.
Delegate Mugler.
Speaking to the bill, Mr. Chairman, I like the intent of the bill, but additional planning time would require localities to hire additional personnel to cover teachers during that time. So that would be the only difficulty I have with this measure.
Any individuals here to support?
Mr. Chairman, members of the committee, I'm Kathy Bircher with the Virginia Education Association. This has been a big issue for our members for a very long time. Delegate Van Valkenburg explained it incredibly well. The volume of work that teachers have and the lack of time to complete that work leads to them bringing work home, doing work over the weekend, an extensive amount of time. Actually, my mother-in-law, who was a school teacher for 32 years in Henrico, ended her career in Henrico County. She said this is the beauty of non-teaching jobs is you go to work to do your work. When you teach, you go to work to get work to take home and do later. And so just having that additional 15 minutes, particularly at the elementary school level where it's far more challenging without question to schedule because of the way the master schedules work in the elementary schools. But those teachers especially need this time, and we support the legislation.
Mr. Chairman, members of the subcommittee, Stacey Haney of the School Board Association. So we do have a concern with the legislation. It is a mandate, and it's gonna translate into a local cost because of because of the way we schedule days. We schedule the elementary school day. Many of our school divisions will need to hire additional staff, as Delegate Mugler said, to ensure that our teachers have the 45 minutes of planning time. So, it's a good idea. I can't take issue with the underlying concept, but it's another mandate on top of all the other mandates. And so, we would just ask that you keep this in mind when we're also looking at the way we fund. This is a place where the support staff cap really comes in because, who is supervising the students when the teachers are having their planning time. And so, that's the concern. Valid, I understand what the delegate's getting at, and it's hard to take issue with that. We just need more funding so that we have enough staff to give teachers that time.
Mr. Chairman, members of the committee, in addition to the points made by the VSBA, you got to remember that elementary days are tight in terms of minutes. To find 15 extra minutes for every teacher is going to be very difficult. So in addition to the costs and staffing, the scheduling is also going to be difficult. So we oppose the bill.
Bette Neal with middle and high school principals. We support planning time for our teachers. We are concerned that the only thing that we might oppose is that it might interfere with IEP meetings, state and federal law, and professional development. Is that, do we understand that that would be also included in this, delegate?
I'm sorry.
The IEP meetings, for example, that would be, so it would be an unfunded mandate and require additional personnel. Thank you.
Chairman Bagman.
Delegate Van Valkenburg.
So I will concede the point that it will be difficult to do this planning period. What I will not concede is that it is impossible. I have worked in schools for the last 15 years. Make the principals and make the administrators prioritize putting planning in for teachers. We tell teachers they got to do all these things, and then it's, we can't tell the administrators to find an extra coverage. And when administrators want to get creative and find coverage, they manage to do so. And I have examples in my school this year where they found coverage for me when they wanted me to be doing something that they needed me to do. And so, in a nod to bipartisanship, I will say that Senator Stewart very ably beat back those calls that it would require local money, because it's a matter of prioritization. And if we're going to prioritize teachers and teacher retention, let's put our energy where it deserves to be. And so I would say we should report this. I think administrators can find it. And I don't disagree with the broader claim that we need more money. That's why we pushed Delegate Aird's bill out this morning. But in the meantime, I think we can find that time.
Delegate McGuire.
So one thing I have to support Delegate Valkenburg on this one is when knocking door to door and speaking with teachers and former teachers, some of the teachers that said they were leaving the teaching profession is they want to raise a family, and they spend so many hours at night grading papers and doing everything else. So I think this would be a great bill to help with teacher retention, so I support it.
Move to report.
There's a motion. Second. There's a second. Members will record their vote. House Bill 273 reports 5 to 1. 5 to 1.
That concludes my mini docket, Mr. Chair.
Delegate Rasool.
Thank you, Mr. Chair. Members of the committee, if I could turn your attention to House Bill 1355. There is a substitute that will be distributed.
And if this is acted upon favorably, it will go to appropriations.
Yes.
So the proper motion is to report and refer.
I move the substitute.
There's a motion. Is there a second to move the substitute? There's a motion and a second to move the substitute. All those in favor express by saying aye. Aye. Those opposed? Delegate Rasul.
Thank you, Mr. Chair, members of the committee. This bill, House Bill 1355, is around community schools. This builds off of work that was in last year's budget. What a community school is, it brings existing resources to students through in a way that creates effective and efficient problem-solving systems, thus creating an environment that allows students to focus. Across the country, there are thousands of community schools that are part of this broad coalition. What it does, it brings together kind of two sides, the capital side, the capital requirements, and the case management. We have examples of some community schools scattered throughout the state, but what we wanted to do is to streamline this. And so, for example, in Roanoke, we have one of our community school pilot projects is there's an elementary school that's going to have a primary care clinic on its campus. In last year's budget, it discussed the need for a framework, and what I have here in my hand is the 44-page result of this framework that came out, which is a framework for Virginia community schools and what Virginia community schools would look like and how this would evolve over time. What was passed out was also a memo from the state superintendent just announcing that this framework was in existence. What this bill does before you now builds on some of that work and continues with a task force to ensure that we can not only instruct on what community schools can look like, but also designate community schools and further help school divisions, especially small, poorer school divisions, to be able to apply for funds to plan what their community schools would look like. So these would be the schools of the future, to think about what the capital needs would be in these campuses, and also the case management that would be required to make sure that our students get the best services. I'm happy to answer any questions, Mr. Chairman.
Delegate Cole.
Thank you, Mr. Chairman. I'm just trying to figure out what is meant by community schools. What the gentleman said sounds like it's just a lot of good management that should be kind of the standard in every one of our schools. So I'm just trying to figure out, what makes his plan for community schools different than just good standard practices for every school.
Thank you, Mr. Chair, Delegate Cole, for that question. As outlined in the 44-page framework, it talks about how we could envision what our schools might look like in the future and what resources we have here in Virginia. So to actually have a primary care clinic on the campus, what resources can be made available to that campus. There's going to be, in this example, a dental chair, a community service board member that will actually be on campus. In addition to that, working with other organizations that work closely on the case management side, what we find is that this kind of innovation doesn't come second nature. And there's a broad coalition, a nationwide coalition of what's called the Coalition for Community Schools that is trying to get us to challenge ourselves in how we envision our schools and moving forward. So what this bill would do is allow them to be able to apply for planning grants to think about, well, what could we be doing on our campuses to better serve the needs of our students in the community.
Delegate Mugler.
Thank you, Mr. Chairman. Question for the patron. Could we not simply give local school divisions the funding and flexibility to meet these academic and social emotional needs of students? I appreciate the intent of and like the sound of this, but I think these are all initiatives that many public schools are already working to provide wraparound services for their students.
Thank you, Chairman Bagby, Delegate Mugler. This is in fact permissive for the localities to be able to apply if they would like one of their schools to be designated as a community school. So this is an additional resource that the schools could apply to in order to receive additional planning funds to be designated. So, in fact, we're not pushing anything down on them. It would be their decision. It's a good question.
Anyone here to speak in support?
Mr. Chairman, members of the committee, Kathy Bircher with the Virginia Education Association. We have been supporting Delegate Rasul in these efforts for the last few sessions. It's important to note that one of the roadblocks I think that community schools face is the availability of funding across different agencies. In fact, questions in previous General Assembly sessions, that's really where the focus has laid, is how are we funding these components if we have a piece that's in the Department of Health and we have a piece that's in education. And so how do we put those pieces together so that we truly can have a school campus that allows for healthcare clinics, not just for the student, but ultimately when community schools are fully working, also for the family, dentists, social services. So bringing those agencies together. So this bill lays that framework out, but allows local school divisions the flexibility to apply for these grants to see what's possible. And again, we appreciate all of the work the delegate has put into this effort, and we support the legislation.
Anyone here to speak? Anyone here to speak in opposition? Members, what's your pleasure? There's a motion to report and refer. Is there a second? Is there a second?
Second.
There's a motion and a second to report and refer. Members will record your votes. House Bill 1355 reports 4-2. Delegate McGuire.
Mr. Chairman, I think we all agree that our children are number one. We may not always agree how to keep them safe, but I think we all agree that we need to keep them safe. I have the high honor of representing parts of Henrico County, Goochland County, Spotsylvania County, and all of Louisa County. For most of the year in 2018, I was part of the School Safety Task Force that was made up of the school superintendent, the sheriff's department, NAACP, and other organizations. And what came out of that report was to put an armed police officer in every public school in Louisa County. So the intent of this bill was to find funding to put an armed law enforcement officer in every public school in Virginia. And what I found out is 55% of schools in Virginia already have armed police officers. However, I met with VACO, I met with the governor's cabinet, and I met with council here, and we before I continue, I want to move for a substitute.
Substitute is being distributed.
Move the substitute.
I haven't, yes. So in meeting with VACO and everyone else, what we found out is some folks in Virginia are not in favor of SROs, so they want SSOs. Other folks want to make that optional, so this substitute does that. And what it does, it creates a school resource officer supplementary fund, so that if a school wanted to have an SRO or an SSO, they would have that option. And again, 55% of schools in Virginia already have that. And with that, take questions, whatever else.
What's it? What's the, what bill number is this? 424. Any questions, members? Anyone here to speak in support? I got it. Anyone here to speak in opposition?
Mr. Chairman, members of the committee, Kathy Bircher with the Virginia Education Association. I'm kind of in the middle with the VA on this one. Again, not having seen the substitute, we were certainly opposed to the mandate. I think there's an opportunity here to really look at some of the funding. We have heard from some of our school divisions after the 3-year grant program that's currently available in the Commonwealth for school resource officers expires, and school divisions kind of have to figure out how to fund it on their own. There might be an opportunity here to use those funds. I will say the VEA strongly prefers and supports school resource officers in the training. If we're going to, in fact, put police officers in our schools, we need to have school resource officers that are trained on working with students, that are trained on de-escalating student behaviors, and are trained on their real role. We've spent a whole lot of time this afternoon talking about ensuring that school resource officers focus on law enforcement and administration handles discipline. So I'm kind of like right here in the middle, because having just seen the substitute, I did want to flag that there's a potential here that it could support those school divisions when the 3-year grant expires.
Thank you.
Mr. Chairman, Stacey Haney, School Board Association. I apologize. I was a little slow. I was still reading the substitute. We support the substitute. We appreciate the flexibility for either SRO or school security officer, and obviously the substitute doesn't contain the mandate. So we appreciate the flexibility, and we certainly hope that the fund is funded so that our schools can access some additional funds to support these positions.
Mr. Chair, Amy Willer with Legal Aid Justice Center. I'm kind of where VEA is in the middle now with the substitute, but I mean, the one point I would make is that we have a lot of money invested in our SROs, and we have the SRO grant fund already, and I think there's a lot on the table during this General Assembly session that I think is more of a priority for us in terms of making sure we have the kinds of support staff in our schools, like counselors and nurses and social workers and psychologists, that I would encourage the General Assembly to look more in that direction before something like this. But I do appreciate the substitute in lieu of the introduced bill.
Thank you.
Will Shaw, Louisa County. I supported this. I couldn't read this substitute fast enough. One of the nicest things about this is it creates the funding stream, and having a school resource officer or school security officer in every school is really a great idea. And this apparently would provide the funding for it, so it doesn't bite the school boards trying to find the money. Thank you.
Thank you. Delegate McGuire.
Move to report.
Second.
There's a motion and a second. Members will record their vote. Fails to report on a 4-2 vote. House Bill 424 fails to report on a 4-2 vote. There is one additional bill in this committee for this meeting, and that is Delegate LaRock's. The goal was to not have any bills passed by for the day, but we will entertain a motion for this bill to pass by for the day. There's a motion and a second for House Bill 678 to go by for the day. Hey, Sam? All those in favor express by saying aye. I just need you to say aye. Those opposed? Hey, I want to thank everyone for sticking with us on this extensive agenda. I particularly want to thank my left hand and my right hand right here with me that have guided me through this process. Believe it or not, we have one more subcommittee. It's going to be another docket, but a very short docket. And I think it's only 4 patrons on Wednesday morning. So, what? No, patrons. There's a lot of bills, but one patron has a lot of bills. Yeah, so I think it's 4 or maybe 5. And we will do that right before the full committee on Wednesday morning. So Again, thank you all for sticking with us. Hope you all enjoy your dinner and your rest.